well because she's a member of our family team at 33 Bedford Row. I have seen her practice grow and develop. She specializes in a number of international issues, but particularly her experience in relation to financial cases, how they are changing and moving on. And this morning, she's going to be looking at costs. That is what I'm keen to draw on for the benefit of all of you who will need to have advice and who may be still lingering in the age where the received wisdom was no order as to costs is how financial cases operate. And some of us who are old enough to remember the days of the Calder Bank will know how much of an adjustment it was to get used to the new set of rules. Seema is going to help us look at whether or not things are changing at the frustration of the courts in seeing the amount of money that is thrown away sometimes in even needs cases where costs are utterly out of control and where the courts seem to have been unable to really make any kind of impact. So Seema is here. She's a very well-known practitioner in the field. Her practice covers international finance, large money cases, and particularly cases with an international element. So welcome, Seema. Can you let us know what's happening in the matrimonial finance world?
Thank you, Constance. Very kind introduction. Welcome, everybody. Good morning. My apologies at the outset for beginning this webinar with such a, I'd say, tedious topic, costs. Nobody really wants to talk about costs. Nobody really wants to learn about costs, but they are so important and very important to keep an eye on at the outset. What I'm going to do is share my screen. I've put together, knowing that this is a webinar, a PowerPoint, which I think would be easier to navigate than the handout. So costs dealt with in financial remedy proceedings under FPR 28.3. So that is the go-to rule and supplemented by the practice direction 28A, which we will come to later on, but that is very important. It's 28A, paragraph 4.4. Now, in relation to financial remedy proceedings, there is the no order as to cost rule. And that is, so if you go to the family procedure rules at 28.3 subsection 5, the rule says that subject to paragraph 6, which I'll come to in a moment, the general rule in financial remedy proceedings is that the court will not make an order requiring one party to pay the costs of another party. So that is the general rule that you would be dealing with at the end of a sort of substantive hearing, final hearing. Why do we have this no order for costs? Well, initially, really, it's because it's very hard in financial proceedings to establish who is the winner, who is the loser. Marriages break down due to the misfortune falling on both parties. It's not a fault on either party, which is what differentiates that from other civil litigation. And of course, costs will, subsequent to the main order, often distorts the intention of the main financial order. So particularly in a needs case, where you have a limited amount of capital, the judge has made a final order. Cost orders are obviously going to interfere with that if one party is to pay a sizable amount to the other party in costs. So going back to 28.3 subsection 5, it says you must have reference to subsection 6. Now, there are 3 points that arise out of subsection 6. One is, so the court may make an order requiring one party to pay the cost of another, first of all, at any stage of the proceedings where it considers it appropriate to do so. Secondly, because of the conduct of a party, and thirdly, and that is conduct in relation to the proceedings. This is often known as litigation misconduct. When the court is faced with an application for costs, it will be considering the guidance that's been given to the courts under paragraph 4.4 of the Practice Direction 28A. The Practice Direction says, in relation to conduct, the courts will first of all look at whether the parties have helped to further the overriding objective, and that is during the litigation. Secondly, the court will take a broad view of conduct for the purposes of this rule. So this is very important, and you will see through the case authorities that I go to shortly in this session that the courts have taken a broad view of conduct and are more willing to make cost orders where they think that there has been litigation misconduct. The courts will generally conclude that to refuse to openly negotiate reasonably and responsibly will amount to conduct in respect of which the court will consider making an order for costs. The Practice Direction then goes on to say this will also be applicable in a needs case. And if that is the case, then the resulting liability will not be allowed to be taken into account when dealing with the computation of assets. So if you do have a cost order in place, the court's not going to take that into account when looking at what assets should be made available to you. The next part of the rules, which you must have regard to, is Rule 28.3 subsection 7. Now, this is a checklist of 7 factors that the court will have regard to when considering a cost application. The court must have regard to any failure by a party to comply with these rules, order of the court, practice direction. That, of course, means, for example, filing a Form E's, Form H, not complying with any orders that the court has made. So that would be relevant there. The court must also have regard to any open offers to settle made by a party. Now, I'll come to that in a moment, but this is very important because, of course, if reasonable and responsible open offers are made, then the likelihood of the case settling is obviously greater, and that is really what the courts have a keen eye on. Whether it's reasonable for a party to raise, pursue, or contest a particular allegation or issue. Often you'll have clients who will want to run a conduct case, or they will want to run a trust issue case, or they want to say that there should be reliance on a separation agreement or prenuptial agreement. The court will look at whether it was reasonable for a party to raise that issue, obviously looking at all the other evidence in the case. And then we've got the other factors, the manner in which a party has pursued or responded to the application or particular allegation, and any other aspects of the party's conduct. And that really is a catch-all provision, which allows the court to look at all the circumstances of the case. So those are the rules in relation to the principles that the court will take into account when dealing with cost orders, cost applications. Now, just dealing with procedure, that there is a requirement under the rules, Rule 9.27 to 9.28, for the parties to file cost estimates to the court and serve on the other side. And this is very important because, of course, non-compliance with this could lead to an application for costs or cost orders being made. So not less than 1 day before every hearing or appointment, each party must file with the court, serve on the other side, an estimate of the costs incurred by that party up to the date of that hearing or appointment. So that applies in relation to the first dispute, the first hearing, the FDA. Those cost estimates must be filed. Not less than 1 day before the first appointment, each party must file file on the court and serve on the other side a cost estimates that they expect to incur up to the FDR appointment if a settlement is not reached. And then again, coming up to the FDR hearing, not less than 1 day before, you must serve on the other side and file at court an estimate of the cost that the party expect to incur up to a final hearing if settlement is not reached. So all along the stage of proceedings, there is a key there's a keen eye on costs and ensuring that those costs are remaining to be proportionate in relation to the issues in the case. Not less than 14 days before the final hearing, you must file and serve a statement giving full particulars of costs in respect of the proceedings which the party has incurred or expects to incur, to enable the court to take into account parties' liabilities for costs when deciding what order to make for financial remedy. I mean, this is important because if, again, we're dealing with a needs case, your client has racked up about £50,000 in costs, that's going to be a liability that she wants the court to take account of. And she doesn't want that to eat into the award that the court will give. So that is very important that solicitors, whoever's representing the party, files that information. Now, open proposals, this is an addition to the family procedure rules. It's no requirement to make open proposals, and that is under Rule 9.27a. Now, within 21 days after the date of the FDR appointment, you must make an open proposal. And it's hoped, of course, that at the FDR, you're going to have a better picture of the landscape. There will be answers to questionnaires given, any schedules of deficiencies would have been raised and dealt with. So you will have a better picture and you'll be in a position to make those open proposals. Again, not less than 14 days before the date of the final hearing, you must file and serve open proposals setting out concise details, including the amounts involved, being of the orders which the applicant proposes to ask the court to make. So the applicant files no less than 14 days before the final hearing. The respondent will then file no more than 7 days after service of the statement under one, so that's after, no more than 7 days after he or she has received an offer from the other side, and serve an open statement, again, which sets out concise details, including the amounts involved, which he or she says that the court should make. Now, I say here, what are financial remedy proceedings? Of course, going back to Rule 28.3, subsection 5, the rule says that the general rule in financial remedy proceedings is that the court will not make an order requiring the other party to pay costs. And in Rule 28.34, the rules say that financial remedy proceedings means proceedings for a financial order, except an order for maintenance pending suit, maintenance pending outcome of proceedings, periodical payments order in the interim, or a legal services payment order. So just applying that, when do the general rules, the general cost rule, which is there is no order for cost, do not apply? So in financial proceedings, we have mainly interim applications. So you have maintenance pending suit, interim maintenance, legal services payment order applications, any other interim applications, as we know very well, preliminary issues applications, notice to show cause, Part 25 applications, disclosure applications. So these are all applications in which the general rule does not apply. Applications to strike out, set aside a financial remedy order, appeals, cost of third parties being joined to proceedings, enforcement applications. So these are all known as clean sheet cases. So they are clean sheet cases because the general rule does not apply, and the general rule in civil proceedings, which is the unsuccessful party will be ordered to pay the cost of the successful party, does not apply. So the courts will start from a clean sheet. But again, when approaching the clean sheet, the court will be putting on that clean sheet any points that it considers is relevant in relation to the conduct of the parties, whether any party has been successful in whole or part, and again, whether any admissible offers made by the parties whether there have been any admissible offers made by the parties. These include Calderbank offers where the general rule doesn't apply. So just looking at open offers and their relationship with any cost orders that can be made, it is only open offers, which open offers being letters showing the position of the party to the court in the course of proceedings, can be shown to the court during a cost argument in which the general rule applies. So we're talking about whether no order for cost, the general rule applies, only open offers can be shown to the court. So Calderbank and without prejudice offers cannot be shown to the court. And of course, you will know that without prejudice offers can only be shown to the court at FDRs, and they don't offer any cost protection at all. Now, just to give you an idea of how these principles have been applied in various authorities. So if you go back to the checklist under Rule 28.3, subsection 7, any failure by a party to comply with these rules, order of the court, or practice direction to which the court considers relevant. In the case of T versus T, which is the High Court case in 2020, the court was dealing with an application of Part 3 of the Matrimonial Family Proceedings Act 1984. It's an international element that parties lived in England, had dual Russian and British citizenship. The issue there was that husband did not participate in proceedings. He made no disclosure at all. He didn't pay anything towards an interim order that was made by the court for maintenance and legal funding. And Mr. Justice Holman then ordered the husband to pay a lump sum to the wife of just over 2 million and to pay her costs on the indemnity basis. So the sort of most serious cost order that you can get for woeful failure to comply with court orders. So that, I would say, is at the most serious end. In relation to the second consideration, any open offers to settle made by a party. This case you may or may not remember, but MB versus EB 2019 case, which involved the penniless artist and the wife who was worth £50 million. They were married in 2000, separated in 2004, although the husband's argument was that the date of separation or divorce should be at the date of 2016. But husband issued divorce financial remedy proceedings in 2017. And that was shortly after a separation agreement was made between them. Now, the court in that case said legal costs that had been generated were wholly disproportionate to what had been an issue. And in that case, the husband had attempted to argue that the marriage had a 17-year duration. So if you look at the stark difference in the positions of the parties, wife was saying it's a 4-year relationship, and he was saying it's a 17-year relationship. And what the court found in relation to that was that that was misplaced and wrong. The other point that he wanted to raise was he had made a full contribution to the marriage as a homemaker. There was a sharing claim. The separation agreement had no relevance because it was entered into under undue influence and duress. All of those points were dismissed by the court. As I said, the court said it was misplaced and wrong. The court took into account, as I've said, the factors under Rule 28.3 subsection 7, so there are the 7 factors there, and the newly drafted paragraph 4.4 of Practice Direction 28, which says the court will take a broad view of conduct. In relation to open offers, the court looked at the offers. The court did make an offer that was more generous than what the wife had offered. So did remark that the open offer made by wife was rather light. But of course, the proposal that was made by husband was far wide off the mark, as can be imagined, massively overcooked. The court also noted that if husband had countered wife's proposals with any form of constructive offer, negotiations could have progressed, and it was highly likely that the case would have settled. Instead, he had chosen to continue litigation in a manner that the court regarded as irresponsible and unreasonable. So again, really important to look at what issues your client wants to run. What is the evidence that supports him or her in respect of those issues? And to give some really firm advice that if you don't win on that issue, you are seriously open to an order for costs. And in this case, it was a needs case that obviously husband was the financially weaker party and ended up with less than what he would have got because of the cost award. Duty to negotiate reasonably. OG versus AG 2020 case. Husband and wife made cross applications for financial remedies. After a long marriage, they separated. There were various international and national assets. There were problems surrounding husband's disclosure in this litigation. Matters were disclosed in a piecemeal fashion, and the judge considered that husband's conduct in concealing a number of transactions was not only dishonest, but futile and frankly inexplicable. Because of the non-disclosure, as you know, it's very difficult to have an effective FDR. And as a result, the parties are going to run up costs, often huge amounts of costs. Certainly in this case, they were exceeding 1 million. And that incurring of expense was related to the husband's conduct. And in that case, the judge referred to husband's conduct as pure bloody-mindedness engendered by the toxic aftermath of the breakdown of the marriage and confrontational personalities of each of the husband and wife. In this case, there was also litigation misconduct in relation to doctoring. Husband had altered an email to suggest that wife agreed to sell when she was actually saying quite the opposite. I don't know whether any of you have had any cases where there's been an allegation that your client has doctored, but if that is the case, then I would advise you to look very seriously at the allegation, but also perhaps at that point to make efforts to try and settle the case, because of course doctoring is a very serious conduct point and will more often than not lead to a cost order and also a finding that your client lacks credibility. And what the judge declared under Practice Direction 28, paragraph 4.4 is, it is important that I enunciate this principle loud and clear. Once the financial landscape is clear, if you do not openly negotiate reasonably, then you will likely suffer a penalty and costs. This applies whether the case is big or small, or whether it is being decided by reference to needs or sharing. So a really important warning that's been given by Mr. Justice Mostyn in this case. In relation to the other factors, compliance with court orders, JB versus DB, High Court case in 2020. Again, in this case, there was a non-compliance with court directions. I think in that case, there was a direction that the courts should attempt negotiations and to try and settle the matter. And in this case, the court found that the husband disregarded the court's guidance, paid such cavalier regard to the obligations as incorporated in my order, the court said, but didn't agree that all of the costs that were incurred by wife should be paid. And of course made, I think in that case, wife was asking for about £50,000 being her full costs to be paid by husband. And the court said that the husband should pay £15,000 of that. The court says the obligation to engage properly in negotiations to see if there's a way around was a significant, the obligation to engage properly in negotiations to see if there was a way around what had now emerged as a very significant impediment should have been taken very seriously indeed. So again, very important evidence that the courts are looking at whether the parties are seriously negotiating this, whether they are casting their minds to serious open offers that are being made. And if not, then as I say, there are cost consequences there. This is in relation to a maintenance pending suit case, LM versus DM, 2021 case. The wife in this case had been successful in her applications for maintenance pending suit and her other interim applications, including legal services payment order. She applied for an order to say husband should pay her legal costs. The court considered that the no order for costs rule did not apply to the wife's interim applications. As we said, they are clean sheet cases. And they are instead governed by a soft costs follow the event principle, and the court may make such an order as it sees just. So what we see here is a slight steer towards clean sheet cases now having a soft costs follow the event principle, again showing that courts are much more minded to make cost orders. Although, and this was also where the wife didn't achieve as much in quantum as she had requested. The judge considered that the outcome of her application was much closer than to the position of the husband's. The court also considered that the wife succeeded on issues of principle. There are aspects of the husband's case that were unreasonable. So the starting point for the court was awarding the wife her standard costs on the application. So that's a starting point. The court then went on to consider that the wife had made no serious attempt to negotiate openly and reasonably beyond setting out in court what her position was in her witness statement. And the court's impression of the wife was that she had chosen to litigate applications regardless of potential outcomes. So on that basis, although the judge made a cost award, he reduced it by 50% for those reasons. So again, very good evidence about how the courts are going to approach all the different aspects of litigation, all the different factors when deciding what, if any, cost orders to make. And the last authority that I'm just going to discuss with you is AA versus AB, again, 2021 case. And this is a useful case I bring to your attention because it contains a good summary of the cost authorities to date. And in this case, it was a very small asset capital case, and wife was found to have been unreasonable in her litigation conduct. She failed to engage in realistic negotiation. She had pursued a claim, a ridiculous claim, it was said, in relation to the party's pet. Costs described were ruinous, and the party's net capital was minus £60,000. So although wife was left in debt by the award, the court did impose a cost order against her to be paid in instalments. So that's, again, a really tragic case, actually, of where the parties have very little or no capital, where cost orders are made because of litigation misconduct. So just moving on, in relation to offers, it is very important that the structure of your offers, whether they are without prejudice or open offers, are realistic. There are huge risks involved in not giving reasonable open offers, or even open offers at all. I mean, open offers at all would be completely in breach of the rules. But as you've seen, there are huge risks there, and it's really not worth taking that risk. The new rules penalise a failure to be realistic and negotiate as much as they penalise a failure to be honest or comply with court orders. So they are on par, which really shows how important the courts are regarding this. When to make an open offer? Well, often in cases you may see where husband may be the sort of main breadwinner, or have a larger income capacity, that offers are made, open offers are made by the husband right at the beginning. and where the wife is waiting for the evidence to come in, that those offers are not made until that evidence has come in. So as soon as the financial landscape is clear, and that doesn't mean that once you have agreed a full schedule with every penny identified, it means that you understand what the broad parameters of the assets are. And if you think that there is any ambiguity, any question marks in the assets, then your offers, your open offers, or your without prejudice offers will include some wriggle room in relation to that ambiguity. So it's not an impediment to you being able to make open offers. In relation to, obviously, without prejudice open offers, make them as early as possible. You can, of course, give and provide offers that are time limited, that you can do it on the basis of no order for cost within 28 days, but if that's not accepted, not thereafter. And it may stipulate a provision, it may stipulate that a provision it seeks may increase over time. So for example, seeking a lump sum to cover my debts, which currently stand at 30,000, but those are going to increase as my legal fees increase. When to make a without prejudice offer? Well, in light of the amendment to the rules that require you to make open offers, we now have to think really what the purpose of without prejudice offers are. So that's something that you will want to keep your eye on. They give no cost protection at all, even in clean sheet cases. And of course, it sets the bar for negotiations at the FDR, because without prejudice offers are admissible at the FDR, and it can influence the court's indication at that stage. Furthermore, at the end conclusion of the hearing, they don't allow the court to see that you are negotiating openly and responsibly. And that is, of course, something that you want to show the court. So the authorities, as I say, do show that the courts have been much more willing to make cost orders which do not meet the parties' needs, particularly where there's been an unreasonable cost spend. So I say, where from here, make the open offer or offers. Be sure to include a provision on costs in it. Make sure you serve your Form H's. Make sure you increase your, you include your Form H's in the bundle, particularly where you want to show how your costs have increased from the FDA to the FDR, or from the FDR to the final hearing. Check orders in relation to costs, particularly where you're dealing with sort of interim applications, but where the no order for costs rule doesn't apply, so interim applications, and an order doesn't mention costs, then the general rule is no party is entitled to their costs. So always check the orders. If you seek cost orders at any stage, raise it with the other side in open correspondence or in skeleton arguments before the hearing. Advise your client as you go along on cost consequences, particularly where you think he or she is running litigation that may be seen as unreasonable, and always put yourself in the judge's shoes. You have to look at the evidence that's before the court, and the court will look at that and will know that at every stage of the proceedings, your client, if represented, would have been given advice. And we know that there are countless cases where clients want to run a hopeless case, which of course are going to be met with those cost awards. And also, as a matter of good practice, what could be helpful is record separately the time that you spend in relation to those issue-based topics. So for example, conduct arguments or trust matters, record your time separately so that you can show to the court how much expense your client has incurred in either defending or running that issue. So that is, I've come to the end of my talk. It's probably enough time, I think, just over half an hour speaking on costs. But I, as you've seen, I've done the PowerPoint. I'm happy to email this PowerPoint to you if you need. And I'm hoping that this has been a helpful session in just reminding you that costs are very important, particularly in financial proceedings. As we know, often there is a finite limited amount of capital that has to be distributed between the parties. And of course, the only people that really benefit from the increased costs are lawyers. And that is something that the court has had in mind. But thank you very much for listening. I think, Constance, you're on mute currently.
Hello, everyone. Thank you very much, Seema. It's an important talk. It's a very good review of the rules and helpful, but it's also intensely practical because, of course, at each stage, your clients are really asking you to risk assess, or if they're sensible, they're asking you to risk assess. What are my chances? What will happen if it goes wrong? And I think that very clear advice is essential these days. It's one can foresee a professional negligence claim if somebody who is not as up to date as they should be is saying, well, basically it's no order as to costs, is a pretty disastrous recommendation. I know we had the opportunity of just speaking briefly for a few minutes before the lecture started, and what struck me was not only your review of the law and the rules, but also you mentioned that this was increasingly your personal anecdotal experiences, that the courts are very open to applications for costs, when probably 3 or 4 years ago that just wasn't the flavor of the month. And it's one of the useful things about coming to this kind of session, is to be able to really know what's happening at the coalface. And I was very interested to hear your experience just doing these cases day after day, or certainly week after week. So thank you very much. And I wonder if I might just take a moment. I noticed that is it Siraja Munira put into the chat box her wishes for International Women's Day to all women who are present here at this conference. And I noticed that all 3 speakers' faces are women. That won't be the case for the whole of the thing, but definitely thumbs up for International Women's Day. And what a nice reminder as we work away at these sorts of issues that we need to stay on top of. Thank you so much, Seema. And I always look forward to your talks and am better informed as a result of them. So thank you. Right, well, I think we are scheduled to move on. First of all, are there any questions about this topic before we go? We'll have a little time at the end as well for a panel discussion in relation to questions, but I'm curious to know if you know, if anything comes to mind just in the immediate aftermath of hearing this updating lecture. Does anyone want to type something into the chat box? I'm sorry, I'm slightly short-sighted, so I have to peer at this thing. Okay, is anyone typing? I can't tell that. It looks as if we've got a clear run then to start with my topic, which is I wanted to revisit what I think for many of us is a recurring issue, and it's about what I still refer to as contact rather than spends time with, which is grammatically not the most elegant phrase. But of course, we're looking just to go back to look at the basics of how contact is working in the real world. Things have been distorted by COVID. We're coming out of that now. And of course, there was a cluster of cases in late 2019 on this subject. And like all things, it has been, the whole area has been affected by recent events about COVID, about families being locked in, not necessarily being able to have the sort of free and easy contact that one ideally would want. But of course, the reality is we are never dealing with the free and easy cases where people would like to be. People come to lawyers when things aren't going well. And of course, we never know who's going to come in the door, whether we're going to be asked by the residential parent. And I know that I will slip inadvertently into talking about the mother, because it very often is the pattern, is that it is the mother who has the larger bulk of caring for the children. And of course, the non-residential parent is very often the father, but those cliches don't always hold. And I hope you'll be patient with me if I am not quite as able to make this gender neutral, because I think when we're talking at a practical level, gender neutrality is important theoretically and in terms of principle, but it isn't always helpful when it comes to the bulk of the cases that come, the entrenched views, the expectations of ordinary people who are trying to make the courts work in a way that improves their family life. So I wanted to go back and look again at what are sometimes called parental alienation cases. They are, that terminology is controversial, and I want to talk a little bit about how, if you can avoid labeling the contact dispute or the spends time with dispute early on with parental alienation, it's best if it can be done. Intractable contact is another phrase, and I think that was there was a retreat from labeling things parental alienation to call them intractable contact disputes. They are often high conflict cases. They will emerge as the bitterness of the breakdown of a relationship begins to take its toll on the next generation. And in some ways, these are for me, the saddest cases when they go wrong, because they are life-changing cases where children who are not able to have a normal relationship with both of their parents. I'd also say they have a particular fascination for me because I happen to start my career in family law with a very serious intractable contact case where it had every fault that you can describe in terms of proceedings that went on much too long, where there was no factual resolution or an inaccurate factual, insofar as there was a factual analysis at the beginning, it was flawed, where the judge became very, he became, and I'm not mentioning his name, I'm told this is going to be available to go back to, so I'm being as discreet as I can be, but where the judge really decided that he disliked the mother and he rather liked the father. And he was so transparent in this personalizing of issues that became a factor in the case. And it went on and on. And I learned one thing, which was when you finally get to the end of some of these cases, the most extreme cases, and where they do move a child from one parent to another, which happened in the case I have in mind, how hard it is, because what emerged was the father who finally had an opportunity to be part of the lived experience of his daughter, to be really fully part of her life, to have her live with him, my goodness me, wasn't it paid back time for mother, because he became very difficult about contact and it simply never worked. And oddly enough, it was a case that I happened to have some idea of what happened in the long term, in the longer term. It was never reported, so I had to have anecdotal information about it. But the tragedy was that the child who was moved to live with the father at about age, I think 11 or 12, by the time we finally got to that radical step, was never happy. And the moment she was 16, left after several attempts to run home to mother, and was taken back. I am told later, I believe it's true, punished for running away, she went back and has lived with her mother since that date. And it was just so difficult to find anything that made anything any better in that case. And I was very interested to see a case that I'm going to come onto where I can read some of the details because it's now been reported. It was a case that came out in late 2019, and perhaps it isn't as well known as it should be, because of course in 2020 we are the attention of the world, and family lawyers inevitably turn to the pandemic and its impact on contact issues. So not much was happening to move or even consider the ultimate sanction where contact goes wrong. So let's start first of all with what is meant by parental alienation, and why I would suggest that as a practitioner, it might be worth really considering at what point you want to use that language, because it more or less prejudges the difficulties, the practical difficulties that occur. And they are hard enough without being pre-labeled. There is huge professional, to be frank, conflict is the word that comes to mind. It's where there are profound professional differences. Those of you who keep track, and it is a useful resource in many ways, of the Kafka's website will notice that there's if you look a few layers in, there's a defense of having a particular expert as part of their team because that particular expert has a view on parental alienation and so on. So when you have different practitioners with Kafka's who will be coming, they will have had the same training, but they come with different points of view. And they also become quite, it's difficult to categorize it because of course cases tend to be different, but where particularly fathers will have gone online, will have read about parental alienation, will be convinced that the reason they're not having contact is the mother's alienated the children against them. Now, all of that may be true, but to start with a fixed assumption is a very difficult starting point. And it does raise a question mark over practitioners on the practitioner checklist. And if you can, if you're going to issue an application, for example, for C100 to have an order made by the court in relation to contact, or even an enforcement order where the contact that's been ordered has not been taking place. If instead of starting off by the clarion call of parental alienation, you simply say what the facts are. For example, although contact was ordered midweek and alternate weekends, it has only taken place one time in the last 4 months, that the mother has made excuses, including the child is ill, the child, without any medical evidence, and set out what it is in factual terms that seems to be the practical block in relation to what is happening, what is the problem, before labeling it as parental alienation. It may be that experts who have been involved and there is already an issue of parental alienation, then you may want to put it in your C100 or your enforcement order application. But if it can be avoided, it is more powerful for the CAFCAS officer who comes to it to be the person who labels this as a parental alienation or potential parental alienation case. And of course, parental alienation is a finding of fact by the court. It isn't just an allegation. It relates to the facts that have to be established in order to draw the inference or the conclusion that this is parental alienation. Having said all of that, what it's about is a case where the child concerned, or often it's children, if there's more than one in the family, and where a child expresses a strong and unjustifiable dislike of a non-residential parent, and where there really is no good reason why the child feels that way, where there's no factual basis to justify that view of the non-residential parent, and where the inevitable inference to be drawn from the facts of why contact is stopped or isn't taking place, or what the child is saying, how that child expresses their wishes and feelings, comes back to the attitude of the mother, or the residential parent, as I should properly say, the attitude of the residential parent towards the non-residential parent. And although it can be deliberate, and those are very difficult and sad cases, they're cases without scruple by the residential parent, that they are sometimes cases where a parent just has so little, the residential parent has so little insight into how their feelings impact on the children, and that this is a subtle but very powerful impediment to a normal relationship with the parents, with both of the parents after the breakdown of the relationship. It's why sometimes these are referred to as high conflict cases, because the impact of how the breakdown between the parties came about has a disproportionate impact on the ongoing relationship with the children. And we're going to hear more about how the court will tackle the factual dispute from which the analysis of parental alienation is to be established. Intractable contact is another way of expressing this. And this is where you have an established pattern of no contact or contact that is curtailed. It's the one that I started by describing as where there's just a clear pattern of default. I hope to sort of sprinkle this with some practical tips, but one of the things that I would put in at this point is that if, for example, you are talking, if it's the non-residential parent who comes to see you, the first advice I would give him is to sit down and make a note of when contact should have, see any order that's in place, or see what a reasonable expectation would be, or what offers have been made, and look at what contact, make a diary. Keeping a diary, which is the basis of a chronology to establish that there's been an unreasonable refusal of contact, is a really important starting point. And everyone who deals with these cases really will be assisted by having that information quickly to hand. Surprisingly hard to remember in the exhaustion that these cases cause for the parents. But it's also a tip if you are representing the residential parent, who may well want to say, you know, their daughter had COVID, or their daughter, there were specific reasons, or that I sent a text or an email to, so that there is a pattern of at least an attempt to cooperate, so that both parties, if they're able to keep track of what happens, or any other difficulties that arise, and so that chronology is readily to hand, that is useful. The labeling, as I've said, is important. There used to be references to parental alienation syndrome. It was that some experts were calling it a syndrome. That has been frowned on and disapproved of for best part of 10 years now. And that should, parental alienation syndrome should be avoided, absolutely avoided. Parental alienation, if it's linked to a factual matrix, is something that should be used with care. I want to start with one of those humbling cases, and it's certainly matched my experience very early on in my practicing life, and I'm just reaching for it, because it's one of those awful warning cases. And I do think sometimes we as practitioners need to, and certainly those of us who sit, need to have some humility about what court proceedings can do. And it's why things which are not necessarily about hammering it out in an effective cross-examination or the perfect skeleton argument are so important. Because when you've really got a serious case of either deliberate or unconscious parental alienation, you really, really do have a hard problem on your hands. So that I want to have a word about the case of Re-A, which was a case that was reported towards the end of 2019. And I think this is part of why it isn't as well known as it might be. And this is a case that was before His Honour Judge Wildblood, sitting as a recorder. And he'd had the conduct of this case for 2.5 to 3 years prior to the whole thing collapsing. And this is the rare case where the father really, there was no criticism to be made of him. He begins the judgment, and it's not a very long judgment. If you want to read a case occasionally where it's not just plucking out a phrase or a recommendation or an observation by the judge, but really look at step by step what could have been done differently or how something might have been done better. This is an interesting one, and it is as well deeply readable. Some of you may know the very expert Dr. Horowitz, who's been around the courts for nearly as long as I have. He's a very distinguished, very sympathetic, empathetic child psychiatrist who's been in huge and challenging cases. I've read many of his reports over the year. But he, the beginning of the judgment starts by quoting Dr. Horowitz saying, and this is the judge in his judgment saying, quoting Dr. Horowitz saying, "This is one of the most disconcerting situations that I have encountered in 30 years of doing such work." And then the judge goes on to say that in his many years of experience, he has never seen anything like it. Well, it's odd because I have seen something like it, and I think many of these things don't get reported. But I mention it because although it's atypical, it's one of those awful warning cases. The father, there was absolutely nothing to suggest that he was unsuited to have contact with his children. He had behaved impeccably throughout, unlike the anecdotal account I gave of the case I observed firsthand, where certainly the father was anything but impeccable, in that he really became quite vindictive when he had the residence order for the child and cooperating over contact. But in this case, there was an ongoing, multiple hearings, an ongoing attempt to try to have, to enforce contact with psychiatric reports. There's a reference to 10 experts over the course of the time this is being dealt with. And of course, there was a referral to social services under Section 37 to see whether or not they would become involved, because the emotional abuse of these children in not having contact with an otherwise admirable father in this case was so serious that, of course, it was the significant harm relied on in relation to care proceedings, so that there was an ongoing, that it started as private law proceedings, but towards the home stretch, the local authority became involved. And the comment that the judge makes, which is as tactful as it can be, but of course it has a subtext which we all can read, and that is that compared with the description of the father and his approach and attitude towards the issue of contact and the progress of the case, was not to be criticized in any way. Wildblood, Recorder Wildblood, said that is also the case that in this case, the mother has deep and unresolved emotional needs, fixed ideas, and a tendency to be compulsive. So she really was somebody who had little, if any, any insight. And of course, the problem is where people have no insight, they can often see themselves as protecting their child from contact. The father, from her perspective, behaved badly towards her. She will see his involvement as exposing the children to risk. It's not a justification, but it is important that as practitioners, we try to understand how people arrive at the point they are at when they finally come to lawyers to try to see if matters can be unblocked. And this is the case where they tried contact orders, they tried psychiatric assessment, and finally they got to the point to the transfer of the child from the mother's care to the father's care. So it's the alternate weapon, if I can put it that way. And that took place, but there had not been the kind of coordination that you would need in order to do that. There was conflict amongst the experts. In particular, those of you who want to perhaps evaluate whether a particular expert is someone you would want to instruct might have a look at Re. I'm not going to mention her name, but it certainly is in the judgment. And I thought how it is actually just worth a moment to quote her advice in this, which differed from the advice of the Guardian and indeed Dr. Horowitz, but it was the person who eventually set up the transfer of these children. So it is X, let's call her X. In written advice to the court 2 years ago, X had said this: "I have absolutely no doubt, based on my extensive experience in working with children, should these children be moved to live with the father, they would emerge from the alienated state of mind within a matter of minutes." And she goes on to say that in her view, what was going on here was that the children had a strong but suppressed attachment to the father, which, if reawakened, would lead to a successful transfer. I find that such an astonishing piece of expert evidence that you only have to take a deep breath to realize that anybody who thinks that an entrenched case of this nature is going to be reversed within a matter of minutes, one really wonders how one could ever have any faith in the delicacy of these cases and the need to support children, and indeed the parent who's got to cope with a child who does not want to be there with them. Whatever the reasons for them not wanting to be there, that is the fact. What is also interesting about this case is, and this will be a very, I believe will find it very helpful to hear the lecture this afternoon, and that is that there was never a finding of fact in relation to what was going on in the family dynamic. So that there was assessment, there was psychiatric input, psychological input, looking at social work input and so on. But it didn't start with what we now think of as the 12J, let's get down to what's going on. And with the benefit of hindsight, Wildblood says that was an error when reviewing this case. So what do we do? Because it's all very well to look at what frankly is just a tragedy and a car crash of a case. I do recommend that it's worth reading with the benefit of hindsight. But these benefit of hindsight cases are very frustrating because we live in the practical world where we know that, of course, early intervention is the gold standard, but getting a hearing date in front of a case can take 5 or 6 months. And all of that while, the pattern is being entrenched of contact being an issue, it being difficult. Children may not understand why mother is upset or why, there's a reluctance. There's a lot of communication going on, even if it isn't direct communication. Children know when their parents don't like someone, and they tend to often ally with the parent that they're actually with, so that the gold standard of early intervention is there. It's in the statute. It's in Section 1 of the Children Act, that any delay is likely to be detrimental to the child. Of course, we know that, and we can see it happening. And the more often the pattern becomes contact should take place, but it doesn't. Contact should take place, but it doesn't. It becomes a reality in itself. So that I would suggest that if it is the party who is desperate to see their child, the non-residential parent, or to see the child in a more orderly way, or to see him from that child for a meaningful period of time, that one really has to think at the beginning of the advice that's going to be given, the reality check, and also to remember that it may well be the residential parent that feels got at, that feels undermined, that feels that nobody understands in the way that she understands why contact is not a good idea. Because you have a professional duty to give advice to both of those parents and to see whether or not there is anything that can be done before or in parallel with court proceedings. Court proceedings do work and contact does take place, and one hopes for the best, but where you have really entrenched views, you have no findings of fact and no prospect of getting a 2-day court hearing it can be the best part of a year. I'm aware of a particular case at the moment where they decided, in fact, that they were not going to pursue a fact find simply because the delay it would cause in actually getting contact started. The other factors that operate in this system is that I am aware of a particular case just in the last few weeks of an estimate of 17 weeks for a CAFCAS report, and that's a Section 7 wishes and feelings report. And of course, when you have an issue or a potential issue of parental alienation, establishing the children's wishes and feelings in light of their age and understanding is very complex because it's the reasons why those children have those wishes and feelings, which is often difficult to get at, and may be so strongly defended by those children, and with the support, indeed the encouragement of the mother, that it becomes worse the longer the time goes on. Sorry. Now, the suggestion that I've tried recently in 2 cases, and I've been surprised that it actually has had an impact, which I found rather interesting because it's simple. And I did this on the building from building on, and you'll see it, paragraph 5 of the handout sheet. I took some quotations, Re W, which was a McFarlane case in 2012. But of course, it's not, sometimes it's not the case that is the most recent that's the most helpful. It is actually worth going back to those broad statements of principle, because they are, I'm surprised at how often they can be overlooked or not be included in, say, a skeleton argument or a position statement. And they are the clarion call. The first, and Re W, is that parental responsibility should be the basis on which these cases go forward. And that the idea that the court will solve these problems for parents, and indeed that it might micromanage, they've tried to leave that behind because there just isn't enough court time. But the culture or the approach to issues where contact isn't working for whatever reason needs to go back to the root responsibilities of both parents, both the residential parent and the non-residential parent, to act in a way which respects the child's need for contact with the non-residential parent. That is half of who they are, genetically and personality. I sometimes think that is part of the problem as to why the contact doesn't take place. The residential parent sees the non-residential parent as the bit of their children that they don't like. It is part of how these things become so complex. McFarlane has said, and it's been for 10 years now, the case that parental responsibility should be given prominence, great prominence, he refers to, in cases where there are private law disputes. It is unsatisfactory for a parent with whom the child lives not to comply with an order for contact. So when you are advising the residential parent, I nearly said mother there, the residential parent, you will also have a duty to go back to basics, which are just a consideration, not as a personal attack against the mother. That's never necessary, and it won't work, and she'll go off to other solicitors. But to say, well, this is what the court is telling us, and this is where we need to start. What do you think about that? How do you see it as, how do you help this child to have what's going wrong from your point of view? But to go back to these very powerful judicial indications. I've taken a quote which you're free to use in your skeleton argument or your letters before action. Parents, both of who have primary care, both those who have primary care and those who seek to spend time with their child, have a responsibility to do their best to meet their child's needs in relation to the provision of contact, as they do in every other regard. It is not at face value acceptable for a parent to shirk that responsibility and simply say no to reasonable strategies designed to improve the situation in this regard. And you're able to say to the residential parent, you will meet this when and if we need to go to court. How could we possibly make this better? Before Mumby reinforces this, it has to be emphasized that parental responsibility is more than a lawyer's concept or a principle of law, and that it is the parents rather than the court or the state who are the primary decision makers for determining and delivering the upbringing that the welfare of the child demands, and that ultimately the burden for resolving parenting disputes rests with the parents who share PR. So the starting point with the residential parent is, how can we fix this? How can I help you make this better than it is at the moment? It's worth having a look, if those of you who like to read cases in full, re-HB contact. And it is sometimes worth. So when I have a conference in chambers, I do occasionally print out the odd judgment and just say, you might want to read this. You know, it's less confrontational. I hope I'm never confrontational with parents. I do give clear and firm advice. But I find that the more one is able to say, well, look, this is how the court sees it, or this is what we have to try to do, it takes the pattern of yes, no, yes, no. It's almost like a pantomime, potential breakdown of relationship between the practitioner and the parent, and introduces a neutral third party, which is the guidance given by courts. I mentioned when I started down this path that I had two examples recently of pre-action protocol, and certainly where you have a case where alienation is likely to be an issue. And, you know, there comes a point where I'm not suggesting one pussyfoots around it, that you want to identify it early on so that you are able to identify it in relation to the C100 application or the enforcement application that you made. And I would suggest, and this has actually worked, in sending a letter to the other side, and if I can stand in the shoes of the parent seeking contact for a moment, just a letter that says that, look, I'm aware from Mr. X has come to see me. I'm aware from what he tells me that contact is simply not taking place in the way that was envisioned at the breakdown of relationship, or in the way that you no doubt would want it to do so. I'd like, you know, I have, you know, you both have parental responsibility. I included a quote from the parental responsibility cases, that these were long established. And then to go on in the letter to say, it occurred to me that perhaps the place to start would be to simply ask you, why isn't contact working from your point of view? Now, there is an element of small guile in this, in that it may be that you actually get an answer which is useful. Well, I said all along that I couldn't cope with contact on a Saturday and nobody would listen. And if you could do this on a Sunday, you know, we might get somewhere. I haven't had that response, but it may be a response that comes back, in which case, yes, it's worth looking at that. But the reality is that you will often come back either with a parent who won't respond at all, or you come back with something which is abusive and aggressive and completely unreasonable. But at that point, you have crystallized, or have the potential to crystallize, what the issue is. If the parent is really being unreasonable, you know, he was horrible to me, I'm not having it, then you've got in your C100 the opportunity to say, efforts have been made to write to the residential parent who's unable to say why contact isn't taking place or refuses to reply. And there are concerns that this is this breakdown in contact reflects an inappropriate influencing of the mother contrary to the child's needs for contact, so that it is highlighted. And where you have really clear-cut response, you can say the mother's response to these questions, it's quite clear that she has no intention of facilitating or even permitting contact. And I would ask that this case is given a priority, that the judge gives immediate consideration to fast-tracking this to what is called the Kafka's pathway, which is a special service. It is very hard to get into that, and of course, it's a pathway that really is predicated on it starting at early on in the proceedings, and with all of the delays that are just inherent in the court's inability to really look at how just to provide a service that does not inevitably involve the delay, which is detrimental to the child, and that is the reality. You may be able to fast track this, and to fast track a recognition that a fact finding where you have a non-residential parent who really is perhaps has had a difficult breakdown of the relationship, but where there's no issue of a non-molestation agreement or no allegations raised of abuse, that to indicate right at the outset that you believe this is a case which requires consideration of the practice direction 12J. The other interesting thing that's come out of recent case law, and again, this is 2019, is the case of Re-L. And what the guidance has been up until now, and I haven't burdened you with the cases where the judges have said the change of residence is a last resort, but there are a number of them. I do want to call attention to Re-L, where McFarlane, president of the family division, makes it clear that it does not have to be sorry, excuse me. It does not have to be a last resort. You do not have to exhaust everything else and however long of litigation. The criteria for where the consideration of a change of residence is based solely on the welfare of the child. If it is something that is required earlier than a last result case, then it can be done sooner. And an example of that is Re-L. Excuse me. It's important when you have this kind of case to think carefully about case preparation. I'm so sorry, let me just there we are. Let's hope that will allow my voice to carry through. Case preparation is at paragraph 6 of my handout sheet. And the most important thing, let's start from the shoes of the parent who is seeking contact. And that is that to start with, it won't work in every case because you may have a very young child and so on, but we have a child where from your instructions, there has been a good relationship with that child, where the father's been an active parent, where there are some really nice photographs of taking the child out, or affectionate photographs where of the child sitting on a lap being read a story or something of that sort, that you start with what was the relationship like before it broke down. Because certainly if you're looking potentially at parental alienation, one needs to identify the point in time that things went wrong, so that I would really, and again, I'd suggest that given the costs of litigation and how hard it is to be the perfect solicitor, spending endless amounts of time when budgets are so narrow and parents' resources are limited, that if any of these questions in my list appear useful, it might be worth sending them out to the client to consider beforehand, and perhaps they might take the time, if they're able to do so, to write something about that. Parents who are having a very hard time seeing their child often would like to tell you about when times were better. And also a little, and I do say a little, about how the relationship between the parents broke down. It isn't what the case will be about, but it can give you insight into where the blockages are occurring. The fact that your client, who may have had a loving relationship with his children before the breakdown, you know, the residential parent can get entrenched in a great deal of anger about the fact that the non-residential parent has gone off and had an affair with someone who is very young. And, you know, these things hurt. And it's good to know about how that happened. You don't want to go down that path particularly, but I know I have found it very useful over the years, and perhaps a little bit eccentric, that when I'm sent a brief, for example, in a family finance case, I do ask to see, and this is going back, things are changing, of course, on the 1st of April with no fault divorce, but I have asked to see, could I just see the divorce petition? Because sometimes that gives me an insight as to why are they so angry? Why hasn't this settled long before you needed to come to a barrister? I know that is perhaps an eccentricity of mine, but it's often given me a little bit of insight. And again, we're talking about 10 minutes worth, not more than that. There are, early on, you will want to ask the non-residential parent, why do you think, what do you think, may I call her the mother for these purposes, what will she say about why contact isn't taking place? That's a neutral way where he's not making admissions that this is true, but what does he think is the block for contact? And in particular, is there any non-molestation order in place? Has she made allegations of coercive control, parental alienation, and so on, so that you have a little bit of an opportunity to anticipate, because you're looking ahead in these kinds of cases to see what the response will be. Is there any supporting background evidence in the form of texts or emails contemporary to whatever the dispute was? Again, it's a question of proportionality, but if something goes seriously wrong at a moment in time, it's better that you know about it upfront, as it were, in terms of case management. Is this a case where the child has suffered harm? Sibling influence is important, and it adds the argument about speed, because you will have, for example, I'm aware of a very recent case that's ongoing at the moment, where the two older children are 16 and 14, and they very much see the breakdown of contact as something where they are supporting their mother. But there's a 5-year-old who has a really affectionate relationship with her father, but you can see as time goes on that she will be, the risk of being absorbed into the older children's views, which have become very entrenched. And again, if that is something that may be a factor, it's worth putting it in the C100 that this case is urgent, because although Florrie seems delighted to see whenever contact has taken place, it is there's a grave concern that that she is becoming absorbed into the older children's attitudes. What have there been any attempts to put things right by the non-residential parent? And have there been good faith efforts to put this right? And again, this can go into a C100. The father has made, the father's case is that he has shown great patience and so on in trying to put this together. Pre-action protocol and practical support. Pre-action protocol is the letter before action. And I think that I would put into pre-action protocol just the question, the quoting of the responsibilities, and either the failure to have a response or the response that clearly indicates there's an issue of parental alienation coming along the lines. The children don't want to see him, they think he's horrible, and so on. Practical support, you may want to signpost some of the practical facilities that are there. There are precious few. It's a pity that Cafcass controls access to SPIP, the Separated Parents program, so that you have to be in litigation before you can access it. But there are some other web facilities. Now, the residential parent, again, you have a responsibility as the legal advisor to explain what the law expects of that of the residential parent. And I've already gone through that in terms of the highlighting of the importance of parental responsibility. It's important that a solicitor is able to support their client, but they also need to be a reasonable guide to the court's expectations. That it may be that your duty there is to look at, was there a fear of, say, coercive control in the mother, and she fears the children being caught up in it, or being put down regularly, or undermined, and that is clearly what is set out, so that there are reasons as to why the mother feels she is acting reasonably. Any practitioner who deals with this kind of basic level, but the most serious end of a basic level problem, which is how to make contact work, needs to have an armory. And I've set out some of those things at 9. You really need, I would print out the website material from local contact centers, because you may, if there are allegations that have to be resolved, you may want to have suggestions as to whether supported or even supervised in extreme cases can get contact going, so that when Cafcass comes to make a report, there's something there to report about. You might want to keep your list of independent social workers who have experience of dealing with contact, alienation or intractable contact disputes. You may want to have a look at the expert's name in Re-A that I didn't give you, but is there for all to read, to see whether she is someone you might or might not want to have on your list of potential experts, or if that person is suggested as an expert, whether you would perhaps want to have some idea of things that had not gone as well as they might have done in the future. So that I want to end because I think, when you have that for Hedra, the first appointment, and whoever you may, as a solicitor or a legal exec, may be representing the client, or you may be instructing counsel, and hopefully counsel will know these things. But I have been surprised over the years how seldom it is that someone's position statement or someone's skeleton argument does not begin, and I don't know quite how the handout sheet went a little bit wonky, but it has. But if you just press on after I've given my name and details, that the contact between a parent and child is a fundamental element of family life and almost always in the interest of the child. You'll remember that as long ago as 2014, the Children and Families Act came in, and that actually amended the Children's Act to say that there is a presumption, unless the contrary is shown, that involvement of the non-residential parent in the life of the child is to be the starting point, so that you start off with a little bit of law beneath your feet, and that the judge who's dealing with whether or not interim contact should be recommended on that first occasion is able to have a quick reference to, in any short form judgment or any questions, a good judge will look at the residential parent and say, why isn't there contact? You know, straight off, and it's, oh, well, I think there should be a relationship, but it's all too difficult, is more inclined when he's presented with a very clear account of what the law actually says to try to get this going with some contact, even though there may be the important issue as to whether it is necessary to have a fact find as part of the background. We all want these cases to be better. They take great human skill as well as legal skill. And although this talk is not just a list of cases or the most recent cases, I hope it will be helpful in thinking, just revisiting quite basic principles in terms of how you prepare cases, what evidence you need to gather, understanding your client and where he would like to be, but with a cautionary tale, because when it comes to enforcement, you've got an unpaid work enforcement. I don't think there's anybody in the entire family group at 33 Bedford Row who has had any experience of any order for unpaid work. It's just bound to make the residential parent even angrier and more wasp-like than he or she may have been before. It's there. There's the, and of course you get the atomic bomb of solutions, which is the changing of parental, of the parenting, of the person who does the parenting. And there seems to be very little in between, so that your skills as a human being, as an advocate, as somebody who has an insight that is more than just a textbook, is able to adapt some of the principles and experience that we all gain as we go along. And I do wish all of you dealing with these cases, and I don't do many private law cases these days, the very best of luck. They are in their ways, although at one level they are simple, they are hard, they are complicated to get right and to get the right result. And I really do hope that it goes well. I hope we'll be able to talk a little bit later on, and we will get, I think that is time to bring this lecture to an end. We have some very interesting ones, and we're going to have a little break, and I'm going to get a nice tall jug of water. Thank you for the kind comments in the chat box. So there we go. Good, and I see a very cheerful face, but I think we're due. Let me just get the schedule. Are we due for a 10-minute break now? I'm delighted to welcome you all back and hope that you had a cup of tea. I certainly have benefited from a hot drink, but also I've benefited from Ayesha Hasan's kind offer to do a swap with me so that my voice can have a little bit of a rest. It is such a pleasure to introduce Ayesha, whose work many of you will know. She's been a speaker before on these lectures, and she is the very distinguished head of 3 Dr. Johnson's building. It's where they have a strong family team. She is known for her work in matrimonial finance, but also her work in international law, where there is an overlap with the sort of case which will involve a good knowledge of the expectations of families that bring into the litigation arena a different experience of Sharia law. And it is something that we all need to be better informed about and to understand if we're going to meet our clients' needs. So that I, with great pleasure, welcome Ayesha to address this issue on behalf of the seminar today. Welcome.
Thank you very much, Constance, and I'm very sorry. I hope your voice re-emerges. It is one of the things that we as lawyers rely upon for our livelihood.
Well, I'll put mute on so no one will hear me coughing.
Not to worry. Good. I think it's just still morning. So good morning, everybody. And thank you for coming to the seminar today. I'm usually much more comfortable when I can see people's faces when I talk. But I'm going to, first time I'm doing this on webinar, so please bear with me. I haven't got any slides as Seema had. I'm much more interactive when I speak with the audience. So please, when you hear me speak, and if there are any questions, just type them into the chat box, and hopefully at the end of my talk, if we have some time, I will try and deal with the questions as best I can, allowing for the time and knowing that Constance has to come back in with her next talk, or Stuart might be stepping in with his first part of his very interesting talk. Now, Islamic marriages, understood or misunderstood? This is something that I constantly battle with when I'm acting for clients and when I read the press and when I read cases. To some extent, I think we've got round to understanding that a Muslim marriage in this country has no legal status. I think that much is now given. At least I really hope it is. But when you see the cases that come forward that I get involved with, it is remarkable the level and the number in society and the educated number that I'm dealing with who know that Islamic marriage gives them no legal rights in this country in respect of what we know as property rights or in respect of their children, that there is so much of it around. And it only comes to the surface when there's a breakdown in that marriage. So there's still a very growing area of litigation going on. And when you see cases, which I will come to, it's also interesting to see the different decisions that come out from the High Court, which of course is great for lawyers because it gives us more ammunition to argue all sorts of marriages can be valid or invalid, because just look at what this judge has decided. But we do know at the end of the day, an Islamic nikah is not a valid marriage. And that's what you should go away with today. If nothing else, you should go away with that understanding, irrespective of all the tweaks that are coming out. Just make sure that you can spread the word, because clearly I'm not doing sufficiently well enough if this is still a growing area. The first time I delivered a lecture on this was in 2016. And it was interesting then that there was this genuine belief that because it was a nikah in an overseas country, it kind of translated into a valid marriage in this country. Now, there was obviously a fundamental flaw with that argument, because as you all are fully aware, marriages celebrated overseas, according to the laws of those lands, are all valid and recognized in this country. We can't have people duplicating marriages. So we have an agreement to recognize all valid overseas marriages. That does not mean that a nikah performed in a Muslim country, either in the Middle East or in Southeast Asia or in North Africa, means that we automatically recognize, whilst we automatically recognize those marriages with no further registrations being involved, we don't do that in this country if that is all you undergo. So recently, there was confusion caused by the case of Akhtar and Khan. Till it was overruled in the Court of Appeal, it suggested that it was a valid marriage if the parties believed they were getting married. So I'll tell you more about Akhtar and Khan a little later. But what is marriage in Islam? Fundamentally, what is it? It's a contract. It's a contract. It can be performed either in a house. It doesn't have to be a registered building, a licensed building. It could be in a mosque. It could be in a restaurant, an open space. There is no requirement for recognized venue. And what do you need to make it valid as far as the nikah is concerned and your religious norms? Are 2 witnesses. There's no need for a religious ceremony. Most people do have some sort of equivalent of an imam or a respected elder in society who will pronounce a few words or recite a few Arabic verses in order to give it a religious standing, but that's not necessary. You actually just need to have an offer, an acceptance, a consideration, which usually is the dawah, or what we call the meher, and 2 witnesses, and you're done. So it's called a nikah, which I'm sure you're all familiar with, and it is something that's frequently performed in many parts of the United Kingdom. So what happens after nikah? After nikah, young man and woman, if they are young, set up home together. Generally, they live in either with the in-laws, or they live in their own accommodation, or they rent a place together and they start cohabiting. They then have children. They understand that the father has, or believe the father has, parental responsibility because they're living in a married household. One thing to remember is that unless a father in a nikah is actually on the birth certificate, he does not have parental responsibility for that child. The child needs to have the father's name registered, and that gives him parental responsibility. But there's an assumption, because they're living within the community, they are married, they have got children, that they are in some way exactly like they've entered into a civil marriage. The wife, generally, I don't want to stereotype, but let's just, for purpose of this talk, assume the wife is the one who's the homemaker, having the children, husband is working outside, and he's the breadwinner. Roles can be reversed. But on that basis, if there is any breakdown in the marriage, the first port of call in these situations is usually the elders and the 2 families. A lot of Asians who get married, they're not just the couple getting married, the families are getting married, which is why I'm sure you see in many of your financial remedy cases, a lot of the either the mother-in-laws or the father-in-laws intervening as third parties, saying they've got an interest in either this property or that property, or they lent money on the basis that the marriage would work. So there is a lot of family involvement in a Muslim marriage between two people. However, if the mediation between the families is not successful, then of course you reach out to the lawyers and you say, well, where do we go from here? Well, you go off to see your lawyer, and that's when reality starts hitting home. If you are, for instance, the wife or even the husband. Husband may be laughing once he's heard the advice he's got. Wife is definitely crying after she's heard the advice she's got, because she's just been told by her lawyer that she has no matrimonial rights because she's not in a matrimony. So the marriage she thought she had entered into is not valid, and what we know as our Matrimonial Causes Act does not apply to her. So where does that leave her? Well, not in a good place. She has no rights to the home unless she can bring what's called a Schedule 1. You heard a little bit about it if you attended Seema's talk about costs. You would have heard her mention the word Schedule 1 Children Act financial proceedings. But that's really where she can only go. The other thing she could do, which is not often done, is she could sue for her meher in contract, as in, depending on what the agreement was that he offered to pay her. There's a very old case, I think it's Shanaz and Rizwan from memory, very old case, where that was allowed by the court, that you can sue on contract, in a contract, that you owe me X amount of money. Now, I've been doing this for about 30 years. I've had 2 cases where I advised sue on the contract because I realized that A, the Matrimonial Causes Act did not apply, and B, even if it had applied, it was a very short marriage and she'd probably get very little out of it. But this way, if the contract, as I told you, you had an offer, you had an acceptance, and you had that meher, assuming it was £10,000 that he would pay her, then you probably would do much better suing on that contract. So there is that avenue. However, if you've got 3 children and it's a 10-year nikah, chances are, well, you'd have done better on a Matrimonial Causes Act application. So there is that you can consider. I know it's disappointing for the wife because she will show the lawyer the wedding pictures. She'll show the lawyer all the jewelry. She'll show, and some of them actually have a spreadsheet as to which side of the family paid what for their wedding. I recently did a case where I was produced with an Excel spreadsheet saying this is how much we paid for this from the boys' side, and this is what we paid from the girls' side. So it is then with some concern they read and learn that they haven't got a marriage. I mean, you can call it a non-marriage, invalid, but the bottom line is you haven't got a valid marriage that you can rely upon to go for a Matrimonial Causes Act application. Now, why is it that there's so much of these nikahs going around in this country? And there's a variety of reasons. Sometimes it's just a genuine misunderstanding, thinking that they have got a valid marriage. They never thought it was going to be an invalid marriage. Sometimes it could be that they are ignorant, really ignorant, and haven't thought about it. Another reason could be that the husband has 2 wives. One, he's married legitimately, as I say, legitimately under the civil law, but rather than have an affair with the second woman or be in an adulterous relationship, from their own personal religious point of view, because having sex outside of marriage is frowned upon in Islam, the way to overcome that in society is to say, I'm married to this woman. So you have a nikah with her. And the wife knows that she's the second wife. She can't ask for a civil marriage, but she's happy to go along with it because the man has provided her with a house, supporting the children, and is supporting her. So she is in some ways probably better than just being a woman with whom he's having an affair with, because there's, from her point of view, some legitimacy to that relationship. So there could be another legitimate reason not to worry too much about the status of that nikah. There is the other side of the argument that a wife who's been, let's put it, once bitten in a bad marriage, comes out of that marriage with X amount of a settlement, finds a man she'd like to marry now, but wants to safeguard her own assets. Why not? She then decides, making an informed choice, not to have a civil marriage and just go with the nikah. There might also be, and I'm actually involved in a case right now where I was surprised to learn, and I'm acting for the woman, that she's a lawyer from one of our top universities in this country, who met a man also educated from one of the top universities in this country, but who hadn't yet got his decree absolute from his first wife, entered into a relationship with him on a promise that the husband would enter into a civil marriage once his decree absolute came through from the first wife. So she agreed to a nikah with this man, and they had 2 children. And once the decree absolute came through, the husband reneged. So there's no need for a civil marriage because he can now protect all his assets by not entering into a civil marriage. So this poor, educated, and I said to her, how could you possibly do that? You're a lawyer. If you do that, what hope do we have? And she said to me, I trusted him. Now, when you meet a man in the first blush of romance, it's quite understandable that you believe everything they say. But now we are here arguing because she, however, has said to me very clearly, I don't want any money from him. I know what I've done. I just want him to leave us alone. So sadly, it is very common. There's a high population of Muslims living in communities such as in Bradford, Leicester, Manchester, and other parts of England and London. And in my handout, I've set out cases that you can read, that you can savor as to how they're being decided. So the bottom line is the legal effect can be devastating on some of these families. Her remedies, as you know, as I've touched on, could be if she has invested or contributed towards the property purchase, she could bring an action under the Trust of Land and Appointment of Trustees Act. She could say, I've also got a beneficial interest in this property because I've contributed X, Y, Z amounts of money, which she would have to prove, which have increased the value of this property. And therefore, I should have a beneficial share of it, even though I have no legal interest in it. So that's something that she could do. Evidentially, it's harder to prove. Another version would be the financial provision I've mentioned for children under Schedule 1. So it's not just the wife who suffers as a result of a nikah. There's also the children aspect of it. As I mentioned, you may have parental responsibility or you may not for a father. But as far as the English court is concerned, the children are illegitimate. And that is quite a stigma in the Muslim community. Why are they illegitimate? Because they're not born in a marriage, simple as that. So a child born out of a marriage is an illegitimate child. So there's an effect on the children, innocent as they are, because of the decisions made by the adults in this marriage. So it is important to recognize these issues. I mean, the difficulty is that this is not a case where you have people walking into your offices prior to entering into a nikah. You only see these people coming in after the whole thing has gone pear-shaped, that they come in to try and understand where that leaves them. It would be much better if they were coming in, if there was, for instance, a comparison would be a prenuptial agreement. They come in and see a lawyer beforehand, know what they're getting into, sign up onto that, and then go into the marriage. No, here we get it when disaster has fallen, when it's all broken down. And that's the sad part of these cases, because that's the only time you see them. When things are working out, as if you take them on trust and you're in a happy relationship, why would you think that there's any issue here as far as problems arising in the future are concerned that need to be addressed prior to the breakdown? So why does society allow it? Why isn't there some sort of rule here that stops women from doing this? Well, it must be right that we live in a democracy. It must be right that your own personal lives are yours and yours alone for decisions to be made in it. Society will not interfere in your life and will allow you to regulate how you wish to live it. The only time more recently that we've been told how we have to live our lives and where our freedoms have been curtailed have been the last 2 years. We've all been through the pandemic, and the speed in which our private lives began to be governed by our restriction on movements and what we can do. And you still, and I'm sure, are aware that there's a part of society who is not in agreement with the way the government has gone about it. But you're also equally aware there's the other half of the society who endorse and are fully consensual to what is going on. But that's a far cry from marriage and how you want to legalize or not legalize the way you want to have a sexual relationship with somebody. It'd be a step too far for there to be any sort of laws governing that sort of behavior. So where that leaves us is, whilst there'll be no government or no statutes controlling you, you fall back onto what's personal law. A lot of us, some of us who may be religious, some who are not religious, it doesn't matter to them. But for those who follow a particular faith, for them, their personal law is important. To some, probably more important than a civil marriage, because that's the marriage that they recognize in their own faith as giving them legitimacy. So speaking on, as far as Muslims are concerned, there's a great deal of weight on their personal laws and having a nikah. Even if they were to have a civil marriage, they would be racing to have a nikah equally, because that is what they consider to be important to them. So in my view, there's still a lot of education that needs to be done, both with the elders in society, those who have influence on their communities, with the imams, with the mosques, with educated people generally. The word that you need to have a civil marriage to protect not just your own interest, your children's positions. So that brings me to Akhtar and Khan, the very interesting case that got lawyers scrambling all over the place, trying to understand how is this possible? Because Akhtar and Khan, for those who are not familiar with it, was a case that husband and wife had a nikah in a West London restaurant in 1998. And at the time, the husband said that he would have, and the intention was at the time, and she probably was in love with him and thought that he would follow through on his promise, that there would be a civil marriage. However, when the marriage broke down and Mrs. Akhtar brought her application for divorce and financial remedy, she was told, well, actually, by the husband, we're not legally married, so you can't issue a divorce petition. There is no valid marriage here. We only had a nikah. Well, Mr. Justice Williams, who was the first instance judge in the High Court, he announced that as far as he was concerned, the couple's Islamic faith marriage fell within the scope of English matrimonial law. And the fact that they had entered into the marriage with disregard to certain requirements as to the formation of the marriage did not stop it from being a marriage, but it wasn't a valid marriage. And therefore, Mrs. Akhtar could apply for a nullity. Now, as you all are aware, applying for a nullity allows you to claim financial remedy. And that's really where you want to go with this. You want to get an order from the court, whatever the formation of your marriage is, to enable you to get through the gateway to make a financial claim. Because to some extent, I would have thought whether your marriage is valid or not is neither here nor there once your marriage has broken down, but you really want your financial remedies to be addressed. And he gave Mrs. Akhtar that window to go through. Well, of course, the floodgates had now opened, and it was swiftly taken up on appeal to the extent that we had the Queen's Proctor intervening in it. And the Queen's Proctor is someone who only intervenes when there's a very, very serious matter of principle and law that he feels on behalf of the government he needs to address in a case. And his position was very clear that Mr. Justice Williams had overstepped the mark. You could not sanction or legitimize the marriage entered into marriage entered in a restaurant as a valid marriage, because that would run a coach and horses throughout our entire decisions that I've been going, the courts have been going through. So it was overturned on appeal. And if anyone wants to read that, the citation would be 2020 EWCA 122. So whilst there was a bit of confusion at that point, we're being put back firmly in our boxes again and told, this is it, it's not valid. So that really is the state of play as far as nikahs in this country are concerned. A very brief word about nikahs abroad. I've mentioned it already, but you must remember the Latin saying, lex loci celebrationis. That simply says, a marriage celebrated in accordance with the law of the land is a valid marriage. So any marriage overseas celebrated in accordance with that laws of those lands, we in England will recognize it. It is important also to remember, just a brief word on the human rights. The right to marry has always been a right recognized by the English law long before the Human Rights Act came into force. And despite the United Kingdom having left the European Union, it is still a participant in the Convention for the Protection of Human Rights, 1950. And Article 12 there provides that men and women of marriageable age have the right to marry and to found a family according to the national law governing the exercise of the right. European case law has adopted a restrictive approach to national laws in this context. While they may recognize public interest considerations, such as capacity, consent, prohibited degrees, or bigamy, they may not prevent or interfere otherwise with that right. And that's what I was referring to when I mentioned that the governments would not wish to interfere, because we live in a democracy, as to how people should regulate their private and religious lives. And that's reinforced by Article 12. Article 8 of the Convention also provides the right to respect for family life. The Convention follows and reinforces the Universal Declaration of Human Rights, 1948, Article 16, and anticipates the International Covenant on Civil and Political Rights, 1966. Now, I've given you those references. If you wish to read up more about it at leisure, by all means, do that. There has been, certainly, from time to time, a little bit of a rearing of its head by groups who have got vested interest and stakeholders, that the government should be doing more to try and protect women, and whether Islamic marriages are given some sort of recognition or not needs to be considered in more detail. It's been suggested that consideration also be given to the requirement that a civil marriage ceremony has to have been entered into before any Islamic nikah can take place. Clearly, between the same people. You can't have it between different people. But that hasn't gone as far as being set out in our statute books. But it certainly would be moving in the right direction, because it would stop the number of Islamic nikahs taking place. Unless you have had a civil marriage, you can't marry this girl. So there would be that protection, but then it may be the other side of the coin. You're now interfering in our private lives. You're taking a step too far. We don't wish to do that. So under the terms of the convention, the UK had until June 2020 to report back to the Council of Europe on a previous government recommendation requiring Muslim couples to undergo a civil marriage ceremony before or alongside this Islamic marriage ceremony. I'm sure some of you are aware that when you see a church wedding, you see the couple going behind the curtain sometimes, signing a little book there and coming out. Well, you know what they're doing in there? They're signing the register because the building is licensed. So there was some talk about, well, why can't we do something similar? Have a little book there, license the building. Gosh, we're done. Very easy. Same time, We've got the civil, we've got the religious, and everyone's protected. That seems to be too difficult to implement. So the deadline passed. Nothing has further, to my knowledge, been reported since June 2020. Maybe it's been hit by the pandemic, who knows? Regards any such report since the passing of that deadline as to whether UK has made any response to that. So where are we on our, back to the heading? Have we understood everything? Or are we still in that misunderstanding of what Islamic marriages are? Well, the conclusion that I've come to is that the misconception is still very much out there. It still prevails in society, and it will continue. It will continue because of all the other reasons I've set out, which some people would prefer not to have a civil marriage. And we do know that if the courts try to be too clever, the Court of Appeal will not have anything to do with it. They'll slap you down very quickly. So we can call it a void marriage, voidable marriage, a non-marriage, nullity, but none of this gives any clarity to a nikah. It may give clarity to other sorts of marriages, but you cannot bring your nikah under any of those labels. And the only way that you can resolve the nikah is outside the Matrimonial Causes Act. So I hope that gives you a whistle-stop tour through nikahs and marriages. And I did not want to take up too much of your time, but if Constance thinks that I should answer any questions, I don't even know where they are.
In fact, a very interesting question here. Let me see if I can get it to appear. Yes, it's a question from Miss Benson, who asks if the marriage ceremony takes place in a cultural context abroad, but not in the legal context of the land, will the UK court still recognize it?
I think the simple answer is no, because it's lex loci celebrationis. In other words, it must take place in accordance with the law of the land. And unless that country recognizes cultural marriages, because I'm aware that in many countries, there's also a cultural marriage and a legal marriage. And
Yes.
some countries do recognize it. But I'm afraid, Ms. Benson, unless that country in which you're referring to recognizes a cultural marriage, no, we will not recognize it.
I wonder if how many people in the audience remember the case of Mick Jagger and Jerry Hall, who both believed they were married. They'd had one of these beautiful on the beachfront, I think it may have been Bermuda or one of the Caribbean states.
I think it was Thailand.
Oh, was it? Okay. Well, wherever it wasn't in accordance with the law of that land. Both of them thought that it had been, and both of them only found out many years and many children later that in fact they had never been married. Well, fortunately, both of them had enough money to make reasonable arrangements, and they seem to have parted on reasonably good terms. But it doesn't, it's a very big issue in our community in England, because we have so many families who have different religious practices. I keep hoping that they will go for the registration, the requirement.
Yeah.
Jewish marriages are not that different. They are a contract as well. And but they are all synagogues are authorized and are required. They cannot perform a marriage ceremony without having the registration aspect of it. And I always found that quite interesting, because as far as the Jewish community, the Orthodox community is concerned, as far as they are concerned, the actual religious ceremony is the only relevant one. They comply with the registration rules, but that deals with it, that no one can conduct, and because you can only have marriages in authorized venues, if it's going to take place in a synagogue, has to comply with the registration issues. And the Quakers are the same sort of situation. So it's very interesting to see how the law has dealt with that issue. But it certainly can end in tears, I think, is the only way. But what a fitting topic for International Women's Day to have a lecture on this very particular issue. And I'm so grateful for you stepping in, and I have had a chance to give my voice a rest, and I do have a hot drink beside me. So hopefully I will be able to take us on to the next topic, unless I'm just checking to see if any more questions came in, and I don't think so, but we've still got an opportunity at the end of the day. Thank you so much. It's very informative, very practical, and very, very real. Ayesha, that's a great contribution to these proceedings. Right, well, let's see. I hope I'm still in the, I'm in the video link. Okay, good. I wanted to talk today on the issue in relation to what's called external relocation. And what that means is where a relationship breaks down and one party would like to take the child out of the jurisdiction and to relocate abroad. And that is a very high stakes issue because, of course, it will profoundly affect the left behind parent. I don't know who thinks up this terminology, but the left behind parent, how that parent will be able to have a meaningful and significant relationship with the child who goes abroad. It is interesting to see how the court has wrestled with this. We live here in London particularly, but in the UK, where marriages between people from different countries, we're a very cosmopolitan, very diverse community, and where people will often find themselves in London at the start of their marriage and when the children are born. But if things break down, where one party or another will want to take that child and go home, as it were. I've set out the main body of the talk is about external relocation. That means going abroad, and the very end of it, I make some reference to internal relocation, which is where the party simply wants to relocate, but within the United Kingdom, because that also can come to be scrutinized by the court, although the issues can be the farther the distance, the greater the impact. And of course, in relation to non-Hague Convention cases, where there's certainly one that's been reported where the father wanted to take the boys back to Iran, who is a non-signatory of the Hague Convention. So if things were to go wrong or the rights of the mother were very much diminished, he was not given permission to take them abroad. That was a case where it was refused. So let's start by looking at the context of these applications. And of course, remembering that when clients come in the door, we don't know whether or not they're going to be the party who wants to relocate or the party who is not happy about the relocation and either wants to resist it or to agree terms that will be reflected in the future conduct for the family. The situations there, and I do think it's worth remembering right from the start the context of what is happening, because when you risk assess, the client who comes in says, what are my chances of either opposing a relocation or of pursuing it successfully? and that's what I mean by risk assessment. Those will depend to a certain extent by a context-sensitive look. First of all, the first category is where the party who wants to move abroad has remarried, is in a new relationship. It may be that new relationship involves a partner relocating for reasons of work, or that there can be a hybrid where, for example, one I've dealt with recently is an Australia case. Both the new partner and the mother were from Australia and were wanting to make their life there, where both of the new extended family would have the wider family in Australia. However, the left behind parent was English and resisted it. The next one are work-related cases, and they are cases where, for example, the parent who wants to relocate has been offered work abroad or has been posted abroad, and they are complicated because of the time lag between getting, it's chicken and egg, isn't it? Can you, for example, apply for a job abroad, or you need to apply for jobs abroad, because that's where the variety of the majority of the work that you do takes place, or where there's a particular profile. It's hard to apply for that job until you have permission to go abroad, and you can't get permission to go abroad until you are able to say that you have work, that it's a work-related application. So that has its own difficulties in management. The going home cases, those are where they are what they say. It's where, for example, there are a couple of reported cases, an Australian one and a New Zealand one, where the mother of a child came over, got married, came over, spent 5 years or so, and just wasn't happy in England and wants to go back to where her family is, and where she just has never really felt happy in this country, and really does not want to contemplate living here until the child reaches the age of 18. Or probably 16, when their wishes and feelings would be the most relevant. And finally, the lifestyle cases, that is where you just cannot bear another English winter, and you'd quite like to emigrate to Spain, and it would just be a nicer life for you and the children there. And those cases are very unlikely to succeed. It has become harder over the last 15 plus years or so to get permission to relocate abroad. Going home, I would thought, is you can sometimes get it. Work-related, you can build a case, but the prospects of success will depend very much on what is in the best interest of the child. The overriding criteria is the welfare of the child, and that is very much there. I thought it would be worth just starting at paragraph 2 by pointing out just what high stakes. These are what is sometimes called binary decisions. Either you're allowed to go or you're not allowed to go. And the consequences are apparent, both for either you're required to stay someplace where you don't want to be, where you think your life is limited in some way, and that is your fate because your application is refused, or alternatively, if you are left behind, the relationship with your child is almost certainly not going to be as strong as it would have been had you been more on the scene. And as we all know, Zoom meetings just are not the same for keeping family life as warm and close as we all would wish it to be. I've quoted Lord Justice Thorpe in Re G on leave to remove, where he acknowledged that these cases are particularly traumatic for the parties, since each of them conceives so much as being at stake. They are each of them is entrenched. They are very, very difficult cases, and for trial judges. And I pause there to say they're very difficult cases for the parties concerned. They are, the balance is very fine between a grant and a refusal, and the judge is only too aware of how heavily invested each of the parents is in the outcome for which they contend. And also the judges are aware of how the decision will impact on the future lives of the children, and how difficult it will be for the disappointed parent to adjust to the outcome, particularly when they are refused permission to go. When I say binary decision, you're either allowed to go or not allowed to go, I want to return to the case of AY and AS, which again was at the end of 2019 and is a little bit slipped under the radar. I will come back to that in due course later in the lecture, but it is an example of a case where conditions were imposed on requiring the mother to stay in the jurisdiction. It was a case which looked as if it had a pretty good chance of removal, and it didn't close the door to removal. It did say that it would review it in a year to 18 months' time. Of course, the reality is that would have been bang in the middle of the pandemic, and nobody could go back to Australia anyway. So I never heard quite what happened on the review, but it's an interesting example. It's rare though, because usually it's all or nothing. And it is one of the areas where case preparation is just incredibly sensitive, that you must get the tone and content of that first statement right, because if you are the parent who's applying to remove the child, the judge is going to have to trust you to do what it is you say you will do, because you and the child will very quickly establish habitual residence in another jurisdiction, and there will be very little that the left behind parent can do to ensure that the promises you made to the court in this jurisdiction can be enforced in the new jurisdiction. So you really want to go carefully. Remember, and this is basic, but it can be lost sight of, and that is, when can a child be removed unilaterally? And by that I mean just one parent can just up and take the child. It doesn't depend on marriage or even a settled relationship. It is tied to whether or not there is a child arrangements order. If there's a resides with order, then you are entitled to take the child away for 28 days. If you are not, if you do not have it, then a unilateral removal without the consent of the other parent is, or an order of the court, that is unlawful, and it engages the Hague Convention. Indeed, if you go for the 28 days and then decide you're not coming back, you've changed your mind, you don't want to come back, that will also engage the Hague Convention, so that the left behind parent can issue proceedings in this jurisdiction, and that would be a specific issue order as to where the child is to live, and there are robust orders to bring the child back. I certainly had one where I was horrified to discover, this was an American case, that the mother had taken the child to America, and the Hague Convention was engaged, and she said that 6 police cars with armed policemen arrived at the house to collect the child, having received notification of the court order. And it was so horrifying to think the trauma of that for the mother, who had done the wrong thing, but certainly I think did not expect that 6 police cars would go out in force. It was probably the most exciting thing that had ever happened in that rather small California town. we then get to the last category, and that is overstaying. Now, this is interesting. I do like cases where somebody has just thought, wait a minute here, what does the law actually say? Because the judge expressed surprise at JM and RM, and that is a case where there was initially a kind of tentative agreement to go, but only for in the short run, and there hadn't been a final decision made. And the mother, again in this case, said that she wasn't coming back. And she won on the legal point that there had never been a date fixed to return. There was never a date at which you could say time had run out, where she was in breach of anything. And I just love that case because you can get so used to family law where the rules are very loose, and sometimes, the merits element of a decision are so great. And I did like that one because that was a pure lawyer's wonderfully clever, unless you're the left behind parent, where it was just incredibly irritating. It was a surprising result. So I have typed in capital letters, taking a child abroad without consent or court orders is child abduction. And it's a very dramatic term for a very, very abrupt and robust jurisdiction, and that is the child comes back so that the decision is made in the courts in this jurisdiction. That is where you would shift to the Hague Convention, and that isn't the subject of my talk today. However, I am aware of one case in Chambers, and it's a civil case because it's a professional negligence claim against solicitors. And what's alleged by the potential, in fact, it is now the plaintiff, is that when they went to the solicitor to ask about going abroad, they were told, well, as long as the father doesn't mind, you can go abroad, but never realized that that advice is wildly negligent, because you really need to have something in writing or a court order. And it may be that the parent has agreed, but it is very, very hard to prove it. And indeed, in that case, the mother who was going abroad, who then had to bring the child back, and there were all sorts of expenses involved in that, and quite a lot of trauma, to say the least, was looking for redress against the solicitors, who just said, oh, well, as long as he doesn't mind, you're okay. It was just simply very inappropriate advice. So remember your insurance. Fortunately, we do have professional indemnity insurance. The process is interesting. You can have a C100, that would be the normal way of dealing with it. I won't deal with the more unusual route, but the C100, remember, that will combine that's for Section 8 orders, and those include orders in relation to specific issues. Where a child is to live is a specific issue, and of course, the C100 includes it combines the ability of the court to make a prohibited steps order, which is in effect the language of the Children Act, for an injunction preventing the removal of the child. And if you think there's any suggestion that the parent will try to avoid the order or leave the country and get court orders and so on to try to prevent that. In my experience, people come back, they deal with the issues in this court, and they are either resolved one way or the other. So the absolute bedrock in these cases, and it's the touchstone for not only how the court will make its decision, but also how to prepare the case, and that is the just good old grassroots Section 1 welfare of the child and that is the checklist. And if you keep the checklist in mind, you will have a good basis on which to prepare the evidence on which you rely. But also, it isn't just a question of when you're in court. The pre-action protocols are extremely important. The reference to mediation, which I had intended to mention in my previous talk, is part of the pre-action protocols for contact issues. But in relation to a relocation abroad, it's very important that those steps are taken. Roundtable discussions might be relevant to see how many of the issues that are of concern can be met by the plan for the removal of the child. If you're seeking to remove, you have the burden of proof on the balance of probabilities that it is in the child's best interest, it is in his or her welfare needs to make that trip. So the impact on you as a parent is part of the situation, but only very indirectly. And that's a factor that has very much been watered down in the post-pain and pain litigation atmosphere. Remember, again, let's just think about the ones that we probably all have written on our hearts or tattooed on our arms. Ascertainable wishes and feelings of the child. It's when you're taking instructions, you need to know, has the child ever been to, let me just pluck Australia out of the air. Has he ever been to Australia? Has he a relationship with family members that are there? How often has he gone? Does he have cousins or other, good? What does the child feel? Has it been discussed with the child? And again, very appropriately and very tentatively making it clear, because when the Kafkas officer comes to interview the child, it will blurt out that, well, mummy wanted to go, and she says I need to go, or something like that. Children can be wonderfully direct. And so the way in which the topic is introduced is very important in the longer term planning for the case. The physical, emotional and educational needs are absolutely essential. You will need to have a school identified. It may be, as is often the case when someone wants to come here, a school will not give you an open-ended offer to bring a child. They may not have a place, for an 11-year-old when you arrive in England. And the same is true in Australia or America or wherever. So you may have to say, I've identified 3 schools. I have, on my last holiday there, I visited them. They have the following advantages and disadvantages. Look to see if there's an equivalent of a Kafkas report, or get quite often now schools, even ordinary state schools, have marketing material. They have websites so that you can see what they offer and how the child's physical, emotional needs will be met. Emotional needs can be met by a warm and loving family that you're going home to, cousins, the ability to go to school with a relative, a cousin, or and so on. So all of that is relevant to how you prepare the case. You need to have regard to the likely effect on him of any change in his circumstances. For example, these two overlap with, this overlaps with the one before, but do not try to get permission to take a child to America to live if you do not have arrangements for health insurance. I have one case where there was no health insurance, and that was the killer point that it resulted in the mother being required to stay in this jurisdiction. And of course, the terrible kind of catch-22 is that you can't get the health insurance largely until you have the employment, and you can't get the employment until you have permission to go. So I felt very sorry for that client, but that was an inability to meet the physical needs of the child. It would have an effect on him of the change in circumstances to go from a country where there is a national health service to one where there is none. really left too much of a gap for the court to feel confident that the child's needs would be met. Any harm which he has suffered or is at risk of suffering. So, for example, if the child has had all of these cases are fact specific, but if the child has been subject, has health or psychological problems, where the advice you've been given is that, or perhaps a physical condition where a warmer climate is relevant, that's all evidence that you really need to get there in that opening understanding of the case and the opening structuring of the case. And I say it because it's always the thing, if you just tack something on at the end, you give the impression that you really haven't considered the global holistic needs of your child when considering the decision to take them abroad. Oh yes, well, I'll sort out a school when I get there. Or oh yes, he does like to go to Cub Scouts, but you don't have the information about what Cub Scouts are available in the locality you propose to go to, or how a child might pursue its very strong interests and hobbies. How capable each of the parents are, and indeed any other person, that would include a step parent, for example, in relation to the meeting of that child's needs. And that is very important. It comes back to the initial issue that I raised, which is the court has to feel that you can be trusted if you are going to take the child away, not just to talk the talk about contact, but to walk the walk. The judge has to trust that you will do what it is you say you can do. Or even if you have the best intentions to do it, there is in place a practical plan for how the good intentions can and will be implemented. Of course, the court has to have regard to the range of powers that are available to it. Other stumbling block is that the no order principle that you can see at subsection 5 of section 1 of the Act, and that is the court has to be satisfied that when it makes an order, that it is better than making no order at all. And this just makes the need to have an effective application all the harder, because you do get cases at which, well, it may be as good as to live in Australia or New Zealand is as good as living in England, but that isn't enough. It has to be better than. Doesn't have to be much better than, but making an order to go to Australia has to be better than making no order at all. And I've often observed that this aspect of subsection 5 does not get considered in the thinking about the case from the outset. Now, the real bugbear of this area of law is the case called Pain and Pain. And it was, in my observation, it has been probably the most criticized case of any that I'm aware of, criticized Court of Appeal case. And I certainly lost a case because Pain and Pain had been decided 2 years later. And it was a very weak case for a mother who really, it was pretty obvious this child was not going to see the father if it was permitted to go. In fact, the two children were not going to be permitted to see their father because the mother had very little genuine commitment to it. There was a new boyfriend in America and so on. But Pain and Pain had come along, and her case was, I will be so devastated if I'm not allowed to go that it will just affect my ability to care for these children. And if I'm forced to stay in this country, I'm just going to be devastated. And she had a medical report and a psychiatric report. And I remember the judge as that awful question, well, Mrs. Whippman, what do you say about Pain and Pain? And there you are, it's the Court of Appeal There isn't a whole, I did think of something to say, but I'm a little lost now to remember what it was. And she did get permission to go. And I was rather horrified because I did hear afterwards that when he tried to go to have some contact, that she had made a gesture of offering, and he went all the way to New York to have it, to find that she hadn't given the correct address, so he couldn't even find her, let alone put in the application. He went to, I would say, it isn't the right word, the children's MP, but of course it's not an MP because it's America. I think the senator for the state she had, it was New York she was relocating in, and she had gone to the court in America and had the file sealed. So it was never possible to know what had actually happened in America. They wouldn't unseal the file. So, you know, it was a very unpleasant case. I have to say, to my amazement, he has sent me a Christmas card every year since then to let me know, which it's just one of the nice things about doing family law. I never had any civil litigant send me a Christmas card after I'd lost that case, a case for them. So Pain and Pain. Now, this is one of my favorite judges is Butler Schloss, who usually brings just an immense common sense to things. She's retired now. Thorpe was like an alter ego. But the guidance in Pain and Pain, which still is good law, but the emphasis has changed, is welfare of the child is paramount. Okay, tick, that's still the same. There's no presumption in favor of the applicant, but a well-founded proposal of the parent with a residence order should be given great weight. Well, yes, but it has to be a well-founded proposal. And the question has shifted as the case emphasis has shifted to being not just why shouldn't the parent with a residence order or has the primary care of the child be able to go to what is the value of changing the child's residence? There is a shift and it is palpable in these kinds of cases. The next one, is there a genuine motivation for the move and not an ulterior motive to reduce the influence and role of the non-residential parent? Often, in fact, I've said often the non-residential parent. That is important because if the judge gets a whiff that this is about a mother who thinks it's just too much of a nuisance to have all that contact, they haven't got on, she has a new partner. So, and I hate to start with all the cases I've lost, I have certainly won them in my time, but I came in very late, instructed in a case where the solicitor had written correspondence, which was just snooty, unpleasant, demeaning. It never really crossed a line, but the absolute flavor of it was just awful. And of course, the judge came to see that correspondence, and it was pretty obvious that this mother was not doing her best to facilitate contact. She was scarcely permitting it. And of course, that was the fatal blow. Now, I say in my handout sheet that one of the things you will need instructions on is to know what if the client doesn't get what they want, what will happen then? And if you're for the person wanting to relocate, if it is the mother, will certainly be asked it in cross-examination, and she may not want to tell you when you discuss it with her, but you really do need to know what will you do. The second case that I lost was one where she said, I will go. It was another California case. I will go to California and leave the children behind. And that is what happened. So I was interested in that. The new boyfriend won out. No self-sacrifice there. And that in itself, if that is the fallback plan, does say a lot to any judge listening to the evidence as to whether or not this parent can be trusted to put the needs of the children for a healthy and significant relationship with the left behind parent, whether they can prioritize that in the midst of having found new love. She does not send me a Christmas card every year, but I did hear on the grapevine that the children had eventually gone to California when they were older and seemed to be very happy. One's in university in California and the other one came back to England. So I do wish we more often knew what happened to these cases as they go. Now, the New Zealand case, which is Pain and Pain, this is about as far as you can go. And of course, in 2001, and the litigation had taken a year or so to, in fact, probably 2 years to get to court. Going off to New Zealand, there was no Zoom. There were telephone calls. I have had cases where you actually have to book an international call. And so a relaxed contact by indirect means was very much more challenging than it is now, where you have FaceTime and Zoom and so on. But it was interesting because the factual matrix was that the mother had a residence order, but the father was very involved in this case. And when you actually took the, well, this comes out in the case, but when the solicitor would have taken details of how much the father was involved in terms of the day-to-day life of the children, the judge acknowledged that it was about 40%. So this was about as close to a shared care residence as you could. But this is a case where the need to go, it was an all or nothing case, and the mother's trump card was that she would be devastated. She couldn't possibly, cope with staying. And if she was refused what she felt she needed to do in terms of her own, the impact on her emotionally, and the court was able to find, and this is the essence of Pain and Pain, that the impact on the mother would affect indirectly the ability to care for the child. It's an argument I really find personally, I don't have a huge amount of sympathy with. So I'm not sorry to see that there is a more welfare concentrated approach. Again, in Re-C, this is again in 2019 case, the approach of the court appears to be best summed up as the onus would be on the relocator to establish that relocation is the better option for the child than not. That really is just another restatement of the no order principle, but it is the finding that emerges from the factual matrix that is established. So looking at case preparation, the starting point has to be a really good grip. The closer you have to shared care, the harder it is to get a relocation order. You may not have an order for shared care, but if the reality is shared care, the greater the impact on the child and the need to have regard to the loss of the non-residential parent or the unrelocated parent. I think it's worth finding out why the father in this, it turns out that all the cases I've had have been where the mother has wanted to relocate, so I tend to fall into that stereotype. But find out whether the father would be able to relocate. What are his job prospects in Australia? Again, 2019, nobody would have been relocating, even though permission was given, because of course the pandemic came along, and that was, it'd be interesting to know what happened. It is, the Pain and Pain approach is the opposite of what I call the wisdom of Solomon approach. You may recall the Solomon from the Old Testament, who has two mothers saying, no, the baby is mine, the baby is mine. And they're arguing over whose baby the baby is. And the baby is there at court, as they aren't in the English system. But Solomon reaches out, takes the baby and holds it up and takes out a knife and says, I'll cut the baby in two. And one mother says, no, 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 don't do that. She can have it. And he immediately gives the baby to the mother who says, you don't do that. She can have the baby, and says that is the true mother. And I always thought that was quite an interesting approach to litigation. But pain and pain is one that says the one that whines the hardest and complains the most and will be the most devastated is the one who seems to have the better chance of going abroad. Although, as I said, that's falling out of favor. The best thing you can go in on, and usually counsel doesn't come in until it's had a lot of preliminary work, it is to know that
Gosh, I'm so sorry, Constance.
it's catching. Oh my goodness!
Sorry to interrupt. Sorry to interrupt
Zoom.
I'm so sorry. Just keep an eye on the time.
Yes, thank you. You need to prepare to give as much detail about the plan, but to have a really carefully organized contact proposals. Long holidays in the summer, if they are possible, if the father can take that much time off of work. What it costs, what the airfares are, what the train fares are. Is there scope for the parent who's left behind to visit, and how will he be accommodated in the new context of life if the issue is allowed to go, if the application is granted. I am happy to end by saying that in terms of internal relocation, and I do find this surprising, but it is real, that if you manage to move before it becomes, there's not much power of the court to make you move back. The Hague Convention doesn't work within the UK. However, if the parent who wants to relocate, who doesn't want to relocate, gets wind of it, can apply for a prohibited steps order, and parents have not received from the court permission to relocate. I do wonder, though, if that is going to be robustly reconsidered in the light of coercive control, because that kind of reeks of coercive control to me. Every case is different, and I may be wrong on that, but I really don't think anybody's taken on the need of some parents to control the other parent even after a relationship has broken down. So that's a little tip for the future. I have run over time, for which I apologize, and I'm very grateful. And my voice is held up, so the virtues of a good hot cup of tea. Thank you. I think we are ready for the lunch break, aren't we? Good. Shall we reconvene? My watch says Micheal QC to join us. He's always a popular, and fortunately for AstenJ, a regular lecturer on these sorts of days. And I can say, having been both in front of him as a judge, and vaguely I recall having been against him, although that would have been a very long time ago, you're in for not only a good opportunity to review the law, but lots of common sense. And we are so happy to have you here on International Women's Day, Micheal. Welcome. Over to you.
Thank you, Constance. Hi, everybody. Those I know, like Ayesha, nice to see you as well. And the 26, I think, participants we have, nice turnout. I'm talking, as I have done before, on the dispute resolution, alternative dispute resolution, principally arbitration and mediation. I want to start by saying that both forms of solving family law disputes are within the process of family law litigation. Let's step back and just look at the broader concept. Family law litigation is a system provided by the state to resolve issues on the breakdown of a relationship, a family relationship, whether marriage or non-marriage. And it is a resolution according to statewide rules, a system of law. And the system of law will have arisen mostly under the cover on the basis of a statute passed by a national parliament. But it doesn't follow that the resolver of the dispute has to be a full-time professional judge sitting in a court. And what we're talking about is other ways of getting the dispute resolved within that framework of a national legal system. And what has happened in the last few years is that arbitration and it's what I call its first cousin, mediation, have now become recognized rules to a full and final decision that a court will in most cases approve. And it goes further. The system is so clogged by cuts, by COVID, by delay, that in some senses, in some respects, the court system, the official court system, is desperate for mediation to step in and remedy what has become the gaping, creaking holes of an underfunded system. The two main forms are arbitration and mediation, which are quite distinct. Arbitration means that the parties agree to hire, to rent a decision maker who will always be under the main scheme, a fully qualified family lawyer, a retired judge, a practicing barrister, a practicing solicitor. Mediation, and when they select, they agree to be bound by what she decides, she on International Women's Day. Mediation is a shuttler between the parties who's meant to put tape over his or her opinions of their dispute, helping to bend them towards coming to common ground. What are the advantages of stepping outside the court system for alternative dispute resolution? I say alternative dispute resolution. The current Master of the Rolls, Lord Justice Voss, has said, I prefer to call it dispute resolution. There's nothing alternative about it. It's part of, and has become, very importantly, part of the mainstream. One, it's generally quicker. The court system is in mammoth delay. COVID hasn't helped. Cuts to legal aid funding, which some of us fondly remember, it shows how old you are if you even think you know about it, have meant litigants in person who take 3 times as long and clog the system. But if you book a mediation, if everything's right, unless someone's come down with COVID, you get your appointment. If you book an arbitrator, the arbitration happens. And it doesn't depend, like the Russian army stuck in the Ukraine, on the tank in front of you getting out of court because they've finished. You get to the appointed place of the arbitration and it takes place. And it ought to take place quicker. The temperature can generally be lower and more solution focused. And here's something that will become more important: confidentiality. Arbitration is confidential. It is not open to the public. Now, time was, and still is, that ordinary family law litigation is confidential. In my time as a judge, I think I actually wore my funny hat and gown 5% of the time. I ducked when I ought to, only for things like committals, which have to take place in open court. Family court proceedings take place in private. Children cases, nobody robes. The public aren't admitted. And the same is true, or generally true, of financial cases before a judge. There is some pressure, of course, to publish the decision, and that's often cloaked in initials. But there's a huge move and a set trend now to go for what is called in modern jargon transparency. The president of the family division is dead set on opening the court, certainly in money cases. I think the issue is still up for grabs in children cases, the court to be open. And that doesn't just mean that people can wander in and watch a pair of oligarchs or famous actors slug it out in court with highly paid QCs. It means if some local businessman of importance in Coventry is fighting off a financial claim from his wife, that can now be splashed across the Coventry Telegraph. If these proposals go through, and they will, because the Working Party reported a few months ago, and the details are being hacked out. And it goes further still. If a reporter is entitled, as they will be, to report on a financial case proceeding in front of a judge, the reporter can say, well, in order to write my story, I need to understand a bit more. You have filed, the parties have filed papers, documents. Can I see them, please? And the current trend appears to be, yes, you can. Arbitration will now become quite distinct and much more distinct from family litigation in court and still take place behind closed doors. There's nothing, I think, I detect in the current proposals to make arbitration a public event rather than a private event in a solicitor's office or even in a garden shed, as far as I can see. That, of course, will all be, that cover will be blown if and when the parties or one of the parties takes the case back to court, as I will presently describe, by way of what is in reality an appeal, though technically it's not called that. Then you're back in the public forum. And of course, Court of Appeal cases are always in public, and the judgment is reported, though sometimes initials can be used. Is arbitration and mediation cheaper? Possibly. What it really carries with it as an advantage is the costs are known. You're not in this sort of First World War situation of family law litigation. We've spent £50,000, let's waste another £5,000 on an application. It may or may not succeed, but what the hell? The sunk costs of this litigation are 50, let's spend another 10, and pretty soon you're talking serious money, like 100,000 aside. What arbitration delivers is you know what the costs are, the costs of the preparation on each side, the arbitrator's fee, that's it. The arbitration isn't something that takes place outside, and mediation too, are not things that take place outside the justice system. They are under its umbrella. The Children and Families Act 2014, Section 10, and the revision made to the Family Procedure Rules, Family Procedure Rule 3.3, the court must consider at every stage in proceedings whether non-court dispute resolution is appropriate. And there is a thing called a MIAMS, Mediation, Information and Assessment Meeting, which is a little hurdle the parties have to cross in every at the first, an early stage in any litigation concerning children and financial proceedings, unless the court gives you an exit clause, and that will apply principally where there is an allegation that the court is satisfied that there is a serious background of violence or domestic abuse or bankruptcy. Now, what the court is particularly concerned to do is to avoid people arm twisted to go into arbitration or mediation where there is gross inequality of bargaining power because one party is a bully bearing down the will of the other party who goes through the motions of the arbitration or particularly the mediation process, but actually are quivering and nervously afraid of being overpowered by an unfair spouse, not always the man. That MIAMS gate is, we on the Institute of Family Law Arbitrators consider, a little too tilted towards mediation because the push is towards encouraging the parties to mediate and indeed trying to require them to mediate. That is a bit of a nonsense because the essence of mediation is that the parties agree to take part in the process. Compulsory mediation is almost as much a contradiction in terms as compulsory counselling or therapy. It is the essence of therapy and counseling, that you understand what is involved and go through it willingly. And for mediation to work, that's true. So where does arbitration come from? It doesn't come out of a family lawyer's head. Arbitration is a very, very well-established process. It goes back to medieval merchants who had their little arbitration meetings. German merchants trading in London would have a little committee that sorted out their disputes between them, sometimes according to German law, European mercantile law, applying rules that hadn't yet been developed in England. The current statute grows out of that long tradition of merchants sorting out business by colleagues saying, you two metal traders, come before me, we'll sort this out. And if you're a member of the Metal Traders Club, you do it according to our rules. And everything stays nicely in-house, and we will blackball and ostracize anybody who doesn't accept our ruling. And arbitration on that sort of basis is enormously used by large companies and small. And most of the retired judges of the Supreme Court or the Court of Appeal, I can tell you, are spending much of their time in Hong Kong and the Cayman Islands and hotels in Zurich doing international arbitrations where oil companies argue with banks and nobody is any the wiser as to what's going on. Arbitration is enshrined in the 1996 Arbitration Act, which is the modern act. Section 1 provides the object of arbitration is to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay or expense. And by section 1b, the parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. Section 1c, in matters governed by this part of the Act, the court shall not intervene except as provided by the Act, by this part. And you will not find in the Arbitration Act a direction as to what the procedure is. That's to be left to the parties. You will not find either a direction as to what law is applied. That's to be left to the parties. That's the commercial civil system. It's under review at the moment because the Law Commission announced at the end of last November that there will be a comprehensive review of the Arbitration Act. But nonetheless, London is a busy centre for arbitration, as is Singapore and many other places. And arbitration between a ship buyer and a ship builder will have an agreed lawyer chairman or legally qualified chairman, and either side may appoint assessors who know something about shipbuilding, so expertise can be brought to bear. That's not quite what happens in family litigation, and indeed family litigation didn't touch arbitration or mediation for a very long time. Why not? And the answer is what I regard as a serious and very long established misunderstanding, almost 100 years old, as to the underlying principle. Keep this in mind. The whole point of a marriage is a public announcement by two people that they are committing themselves to live together or to be together in a marriage or a civil partnership by some sort of rules that even in our very fractured modern life do reflect some adherence to some sort of common standard. And the more old-fashioned way, it's become deeply unfashionable, but it's still there underneath, that the state, the community, has an interest in the promotion of good family life. It produces happiness rather than distress when it works well. It is vital for the propagation of children, and every study shows that nurturing by the parents, whether they're the biological or the non-biological parents, is a better assurance of the development of personality, growth, and a happy life. So there is a state interest in divorce, and that's why in family life and indeed in divorce. And that is why there is a religious undertow in many cultures that still pervades, even though we're a much less religious society, to what is involved in the breakup of a marriage. Look at the language. Look at the language of dissolution of marriage in English law. It's called a petition. Why? Because the church in medieval times grabbed hold of the mechanism of contracting a marriage, became a sacrament or akin to a sacrament. When you file a petition, you pray for relief. In English, certainly in English law, and quite distinct, as Ayesha will confirm from Islamic law and indeed Jewish law, where marriage and classical Roman law, where marriage was seen as a contract in which the state had very little to do except sprinkle in the temple when there was a holy dance to celebrate, there was something underlying that was not within the party's control. And it was therefore bad to oust the jurisdiction of the court by making your own deal outside of the court process. The courts were saying, we won't let people come to private arrangements, mostly because they sensibly understood that a private arrangement was a license to the stronger party, the husband, to impose terms. When women couldn't own property in their own right if they were married, and when there was the notion of in Latin, the patria potestas, the power of the father, the patriarchy on International Women's Day, the weak had to be protected from the strong. And therefore, it was thought that making a binding agreement when the marriage broke up was ousting the jurisdiction of the court, which is posh speak for telling the court they had no business. And in a case called Hyman in 1929, Lord Hailsham, the older Lord Hailsham, said that the jurisdiction of the court could not be ousted. Now that decision, which didn't come as a huge surprise to practitioners, was misunderstood, because it did not mean you could not try to negotiate. That would be absurd. It did not mean that you could not come to a deal and ask the court to approve it, because you could. What people misunderstood, and still I think misunderstand when they look at Hyman, is what the court was saying is the court is the backstop. If you do make an agreement and it looks as if it's fair and cards have been dealt face up, and the husband discloses all his bank accounts, of which his poor little wife knew so little when they were together, that's an enormously important factor we can take into account. And we might say, we'll uphold this agreement. And that's the principle people often misunderstood when they were grandly talking about ousting the jurisdiction of the court. And it's still essentially where we are. The court is the backstop. It can say, away with this agreement, it stinks. But it can also say, you agreed, you're both grown-ups. You said you wanted to go in front of arbitrator Ayesha Hasan. It looks pretty good. She did a good job. She listened to both sides. She wrote a clear report. What's wrong with this? And it took a long time for that to sink in. It crept in slowly in cases on agreement to settle divorce cases. In Edgar, 1980, an agreement to settle finances on the breakdown of the marriage was, Lord Justice Ormerod said, will be upheld unless the court can detect coercion or undue influence. And here, this wife, she wanted to leave the heir to the H. Samuel jewelry fortune to have an affair with Gardner. Well, that's the deal she wanted to make. Huh. Then the court next grappled with prenup and antenups. In Roman Dutch law and in Roman law, people did agree what was to happen when they entered into a marriage and what was likely to happen when they exited. In fact, that's the essence of arranged marriages, whether they are formal, such as I think, is it the nikah in Ayesha? the ketubah, the written agreement in a Jewish marriage, which provides an exit clause for maintenance. And of course, that's how the landed gentry ran their marriages. They married off their daughters to the next door landowner or to somebody they wanted to impress and ally themselves with, and a bundle of bits of land went with the deal. So what was so terribly wrong, you might think, about grown-ups not listening to what daddy wanted to happen to the castle, but coming to their own agreement to sort out the breakdown of their marriage? In Rademacher and Granatino, our Supreme Court upheld a prenup. It was a pretty remarkable prenup. She was the heir to a German chemical fortune worth about 100 million quid. He was a banker with very little capital who decided to give up banking and become a student late in life. And Mrs. Justice Barron, a wonderful judge, a hugely sensible judge and much missed, said £5 million, which is what he wants to buy himself a mini mansion. So when the kids come to stay, they're on some sort of parity in terms of the facilities and the look of the place they're staying with daddy compared to mummy's enormous wealth and houses on 3 continents, isn't untoward. No, said the Supreme Court. These are grown-ups, they come to a deal and they struck out the £5 million. And he had to pay the costs, and I believe he's bankrupt. That's pretty severe, but the principle is very important. The court was recognizing a new buzzword, autonomy, and it shines through the judgments. I'm told that in fact, the practice of the judges in the family division is not to follow the strict guidelines of the Supreme Court, and they will be more inclined than the face of the judgment records to provide for housing at least while the children are young. But remember, this still nests within the principle of ultimate approval by the court. But it's the court that's saying, we respect your deal. You've made the deal, we're satisfied it's okay, it's the court that's respecting it. And that's quite different from arbitration. And when looking at this, 2 distinguished High Court judges, Hugh Bennett and the late Sir Peter Singer, devised an arbitration scheme, and they used the Chartered Institute of Arbitration and put together a scheme for arbitration with very important elements. There were to be fixed rules, clear rules. If you signed up for arbitration, these were the rules of the game. It was to be according to English law, and that is hugely different to arbitration between bankers, between buyers and constructors of yachts. The arbitrators were from a pool, selected from a pool of legally qualified family lawyers. The scheme was put together as a bit of a gamble because it didn't yet have court clearance. But that was negotiated in the important case of S&S, which I've cited, a decision of Mr. of Munby, who the then president of the family division, who said, this is an arbitration conducted by Gavin Smith, a member of my former chambers, a careful, conscientious and good arbitrator. He's well trained, he's respected, we've read what he says, it's okay. And, said Munby, when a case like this comes in front of me, and because the other side, after the arbitration, doesn't like, wants to go back to that never abolished inherent jurisdiction of the court, we'll chuck it out. Unless something has gone seriously wrong, we respect your initial decision to engage in arbitration, the manifest quality, well-conducted arbitration, and therefore the result. So that is where we are with arbitration. The jurisdiction of the court is still there, but it's in the background. It will only come into play with coercion improper conduct, and something seriously wrong. Now, how do you test what's seriously wrong? An arbitration under the Arbitration Act is confined within very narrow bounds. They're to be found in sections 68 and 69 of the Arbitration Act, which one allows exclusion of an appeal even on a point of law, because as arbitrators smirk to each other and commercial solicitors say to each other after drinks when it's all happened, my dear boy, when you buy an arbitration, you buy the right to be wrong. But the scheme, the children's scheme, which followed the money arbitration scheme, both the children's scheme specifically specifies English law and does not allow the parties to exclude, and it is inherently, it's implicit in the money scheme. The other exceptions to the other get-outs are procedural. Has the arbitrator misconducted himself? Beyond that, the English courts have historically been exceptionally hostile to any attempt to subvert the findings of the arbitrator. So when the so that's section 67, the arbitrator had no jurisdiction. Section 68, serious irregularity. Section 69, appeal on a point of law unless excluded, and a corrective jurisdiction under section 57, but that's only for clerical error. And then oddly, after when our scheme got going, 3 or 4 applications by a disappointed participant in arbitration came before the courts, and they met this strange barrier that the family court, said, well, it's an arbitration, isn't it? We're applying those 3 restrictive sections, 67, 68, and 69 of the Arbitration Act. Oh, and if there was a supervening event that the parties never contemplated, the doctrine known by reference to a famous family law case, Barlow. But we're not going to look at it otherwise. It's a different test to the test that we know is applied if you're appealing from a judge in a money case. But this is an arbitration. Now, this came as a huge shock and surprise, particularly because Mr. Justice Mostyn, who was then in charge of the family list, delegated the hearing of these applications to Claire Ambrose, a Queen's counsel in commercial chambers, hugely experienced in arbitration, but not a family lawyer. And she, in a string of cases which I've noted, BC and H and JB, JB's Mostyn's case, in fact, adopted this strict arbitration standard to family law arbitration, and adopted it to family law arbitration, overlooking what seems to me the fundamental principle of the jurisdiction of the family court had never gone away. Finally, the worm turned, and of the 3 cases I mentioned, at page 10, we have H and H. We now know Mr. H is, he's Mr. Haley. And he appealed to the Court of Appeal. And the Court of Appeal said, no, the arbitration test is wrong. The correct test is the ordinary test applied to an appeal from a family judge. And more recently, Mr. Justice Mostyn in an A&A, which I cite at page 11, boldly says, the attention of Lord Justice King, Lady Justice King and Haley was to align as much as possible challenge to an arbitral award with an appeal in the family court. Challenges under either section 68 or 69 of the Arbitration Act are redundant. Very helpful of him. He was the one who started all this, but it's a noble retreat. You don't have to show that the award was seriously wrong or obviously wrong. It's the it's the test applied, rather hard to define, but easy to see when you see it, to appeals from a family judge. And arbitration has brought itself into line because the jurisdiction of the court has not been ousted. It's been, so to speak, subcontracted to parties who, with exercise of their personal autonomy, want to go to arbitration. That is, to those of us who are involved in arbitration from an early stage and drawing up the children rules, and I ran the subcommittee of the Institute of Family Law Arbitrators, that's where we always thought the law meant to be. And it's a pity there had to be this detour and frightening of the parties for 3 or 4 years to get there, but that's where we are now. Arbitration is embraced, encouraged, and there is a get-out clause if it's gone manifestly wrong, if something has really gone wrong. Mediation is consensual, it's private, it's confidential. Mediators come badged by resolution, the Solicitors Family Law Association, now renamed, or the Institute of Family Mediators Association. But there's no strict control. There isn't the same set of rules, and the amateur mediators would possibly be allowed as well. The mediator is a facilitator, shuttling between the parties. A lot of excellent people are involved in mediation, including retired judges and senior QCs and good juniors, and experienced among the many, many good solicitors who practice family law, have worked both sides because they've acted over the years for one side and the other. It does, in the hands of a good mediator, become a gentle steer towards the sensible and the obvious as the mediation goes on. But the strict orthodoxy that's certainly prevalent when I did my mediation training is you're not meant to take sides. I think that's nonsense myself, but you're not allowed to say that. If the parties reach an agreement in mediation, that's not the end of it. What will happen is they will draw up a memorandum of understanding, sometimes known as a MOU, and they will take that each to their own legal advisors, who will either say, yep, looks all right, or you're crazy, why did you ever sign that? But if the parties haven't had the opportunity to take professional advice, confirm the rough draft that the mediator has drawn up, the heads of agreement, it'll be translated into an application to the court to put it into court words. The difficulty with mediation I found is that search for the common ground means that the more stubborn pulls people to their side. I was very struck in a couple of training sessions when we all got round to crack a problem in mediation, that the result we all got smugly proud of when we gamed it, gave the wife, I said, what are we doing here? We've given the wife 25% less than we know the going rate just to get an agreement. Now, I think that's the downside that you have to watch with arbitration. But whether it's arbitration or mediation, that is appointing your decider, the arbitrator, enabling the parties to discuss and steering them towards such agreement and common ground as can be found, there is still an interface with the court. Why? Well, because it's almost always necessary. Big important point in money cases, especially. Only a court order will give you a full and final dismissal. Remember the case of Vincent Wyatt. Mr. Vince, or was it Mr. Wyatt, was once a hippie, and so was his ex-wife, and they lived in a little hut in Wales. He stopped being a hippie and became a rather rich Scottish oil man. She said, oh, I don't like this deal. And I think it was 20 years after the divorce, got an agreement in principle to relaunch a claim because there'd never been a dismissal. Full and only a court can say full and final dismissal. Second, a hugely important element in money cases is pensions. And as we retreat from awarding lifetime maintenance to wives or partners, and as the importance of periodical payments diminishes, we look at what's been acquired during the marriage, and often it's a disparity between their pension pots. But a court can't tell a pension, but the parties can't tell a pension fund, will you please give 30% of what I've acquired to my ex? Because the pension fund is run by trustees who must perform the original trust. Only a court can slice off a pension and properly vest it in the party it was intended for. And only courts can give, award an injunction if it's necessary for protection. And so in nearly any case, a mediation and an arbitration should go to court to receive rubber stamping, which technically will be the exercise of the court's discretion under Section 25. But believe me, the courts haven't got time to look through agreements to work out whether they would have done the same or not. And there's now available online a string of draft orders and interfaces between the court and the arbitration process, and I've semi-stolen one of them and annexed it to the handout. The third kind of non-court resolution is what everywhere else except us calls early neutral evaluation. We have it as the financial dispute resolution when parties come before a judge and say, here are the facts, and there's a 20-minute short firing by party A, 20 minutes by party B, and the judge scratching his or her head saying, well, I think weighing this up and not knowing the case and not having heard the evidence, isn't the answer something along these lines? Go into the corridor and agree. If you're rich, you get a high court judge doing this for a whole day. What I hated was when I sat, we had to do 5 of these, 5 parties in a day. District judges perform miracles doing good FDRs, but it is an undervalued aspect of what most other legal systems do more energetically than we do. Somebody saying at an early stage, before we have drowned in files, let's get everything onto one sheet of paper and let's see where it stands, isn't the answer in this range rather than in that range. Many American jurisdictions that I've discovered in a research project I'm engaged with looking at how other countries deal with finance and children have settlement conferences, not FDRs where the judge sits back, but a judge actively engaged in pushing and negotiating. Very prominent in some but not all states of America and very much used in Canada. Lastly, Constance, you want me to deal with questions as well?
Yes, if you don't mind, but take it at your...
I just wanted to mention collaborative law.
Do you know...
How many questions have you got?
Yes, a collaborative law, I would like it. I think it would be very useful if you could deal with collaborative law.
Collaborative law is a very interesting. It takes arbitration and mediation and it blends it together. I went on to, I looked it up. I've been to training sessions where it's explained as a process by which the parties agree to solve. They agree to park the litigation for the moment. They agree that they will, they keep their legal advisor, but have a sort of manager of the collaborative process who can say, we're going to talk about this. We're going to decide whether we can agree this aspect of the case, maybe the disposal of the matrimonial home. We're going to try and sort out whether other children going to live in Glasgow or in Godalming, because then we can see what financial consequences follow. And we agree to park litigation for the moment because we're focusing on finding out what's in common. There are variations on it, and some mediators are more laid back than others, and some jump between. The better ones can jump between wearing a mediation hat and an arbitration hat. So it's really a very exciting development, still in its early stages, but it needs willing parties. It needs sophisticated advice to each of them, if it's not become a bit of a dog's dinner in which one party over-dominates the process, and is an aspect, I think, of parties that what Lord Phillips said in Granatino is the parties asserting their autonomy. It's their lives, they have to live with the consequences, and the court should drop on Women's Day and forever what was the very well-meant and sometimes not so well-meant patriarchal mode of resolving disputes.
Thank you. What a very good note to end on. Yes, that's a very useful review. I have to say, I would welcome the opportunity to discuss collaborative law with you. I've found it sounds good in theory, but it is very rare to actually find either the lawyers or their clients sticking to the spirit of it. And I have found that frustrating, but they're just, I often think there's got to be a better way. It's just finding the better way. And the transparency rules that are being proposed are absolutely extraordinary when you get down to them. I think we can still, they've extended the consultation period until the end of this month. I was trying to find it on my laptop, but while you were speaking, but I couldn't find whether or not that is still the case. But it is the most extraordinary thing to make public, and will certainly increase the demand for arbitration.
Well, that's what I think. I think we should sell ourselves as confidential.
Yeah, I
one
think
of the issues, one of the things, what we said, it was partly a conceit, but it was true as well. If it's confidential, if we don't have people wandering in, Swedish tourists wandering in, and we don't have the wife's brother wandering in,
yes,
shouting from the back of the court, we can get at the truth. And there was a dirty little secret here as well. For years in family law, husbands, particularly when tax rates were 95%, husband would say, yes, I do have a little bit in Switzerland, and the court could operate on it. Then I'm afraid a judge was appointed to the family division who'd been a tax hound for the Inland Revenue. And he said, sorry, these cases must be shopped to the Inland Revenue.
Yes.
But it's also true in children's cases. You can elicit important concessions and confessions from people in private. Now, why should all that be noised about? And in the care system, I hated the idea. He was sitting in Milton Keynes dealing with people from the least fortunate sections of the city, from a dreadful neglected estate. How on earth could you even, difficult enough taking people's children away, but the risk of having someone sitting at the back yelling at you, and worse, rushing the court, made the job even worse. So there were lots of good things to confidentiality.
Indeed, there were, and the pendulum will swing, as probably you and I have of our practicing lives. Thank you so much, and I really can recommend.
Sorry, Constance,
looking for an arbitrator.
I think there was a question for Micheal from Tahir. He's had his hand up halfway through the.
Oh, I didn't see that. I'm so sorry.
So
yes.
Do you want to ask Tahir to ask?
Yes. Hello? Is he still here?
Yes.
Tahir, are you there? Do you want to ask your question of Micheal now?
Hi. Have I got you? Have I got you? There's chat. Yes, that's you, Constance. Right. Yes. Question is?
I can't see it come up in the box, or I'm not sure that the attendants at the conference can actually unmute. If you could, just to make sure we can cover this, if you could type your question. We are running into Stuart Barlow's time, but I'm just wondering, Stuart, if you would give us a few minutes,
got a question.
it would be very helpful to have a question.
That's absolutely fine.
Good.
And I will stay around to be with the Q&A session.
Oh, that would be very helpful, and
Okay.
then there'll be time to do that.
So we could park the question, go on to Stuart if you like.
I find this such an interesting lecture because, as I said, you have been a featured speaker on previous occasions, and every year when it comes around to it, my own thinking has developed and evolved. I just think that it really is going to be that you can get a really first-class judge to deal with your case, and in fact you don't have to. I've been speaking to, in fact, a colleague in Chambers who's chosen arbitration for a matter that she's dealing with in her family, and she's really come back raving about it, not as an advocate but as a participant, and I thought that was the best kind of endorsement. But thank you so much for staying on for the panel discussion. DS,
Deaton Solicitors, could you kindly elucidate further on collaborative law? Not sure I can really. I know much more about arbitration and mediation. I've gone to this very good training session. Suzanne Kingston, who's a powerhouse in the development of arbitration. It's as Constance and I describe it. It's a sort of how shall I put it? It's been created on the spot. You agree to park the litigation. You agree that you will not be arguing your side in the room. You'll be searching for a solution. You agree that offers will be privileged. You agree that if the manager of the collaborative session says, right, let's resolve this, you follow. I'm not sure I can do more than say it opens avenues under somebody's control. I hope that's helpful, not just ducking it.
Generally speaking, you need to have both lawyers for both parties who are trained in collaborative law. There's a qualification. And I know some chambers will have all of their family practitioners who do finance trained in collaborative law so that they can offer that service. But it is going to be a very interesting exercise. There's a website, collaborative law.
I looked at, I can't remember, it wouldn't be fair. I typed in collaborative law, not a very good solicitor's website, and they made this point. This type of process can cause a lot of distress for the people involved. It doesn't suit everybody.
Yes, I think you have to let go of that. I've got someone
coping well with the dispute for it to work.
Yeah, yeah.
And I thought that was a splendid thing for the solicitors to acknowledge. Okay.
Very interesting. Good. Well, I think we are coming to a very practical, very important topic, which is to welcome Stuart Barlow back. And Stuart brings a really special perspective, which is he is a solicitor in a well-known firm that I always think he's the voice of Stuart Barlow. Is if I ever had to have bad litigation advice, I would hear Stuart's, I would choose Stuart's voice to tell me about it if things weren't going to go well. He's, I believe, 40 years of experience. He's very well known for his work with grandparents in particular. He set up a help group and a resource group for that particular coterie of people who have struggles in the family court system and limitations on what can be achieved. A very practical, very useful book about dealing with litigants in person and Mackenzie friends. So just someone who knows this from the cases from the start to the finish and sees them through. And I'm very, very pleased to welcome Stuart back, who's going to tackle the whole exercise of fact-finding. The atmosphere has changed, the climate has changed, and tell us what's happening. You're very welcome on International Women's Day, Stuart.
Thanks, Constance. It's wonderful to be here, and I consider it to be an enormous privilege to be able to share the platform, as it were, with some great speakers. In fact, I've been here all day because I was so fascinated by what was being said. I thought I can't miss out on the opportunity of not only dealing with the speakers, but also dealing with the subjects. So it's great to be here, and I'm now turning this session to a subject that is very much dear to my heart. And we're going to be doing it in two sessions. The first one is to look at fact-finding generally, and then we're going to have a tea break, and we'll look at fact-finding within children proceedings as related to litigants in person. So I hope you'll find that helpful. It's certainly something that's very practical from my personal point of view, and I hope that you'll find that too. So welcome to this session on private children law fact-finding hearings in children cases. As Constance has said, that it is something that's coming before the court and has come before the court, and I suspect will come before the court a lot over these next years. So I'm Stuart Barlow. I've been working in the area of family law for over 40 years. I've conducted many private children cases during this time, including quite a number of fact-finding hearings. So much of what I have to say today is a reflection of what I have learned over those years. I have provided a set of notes to run alongside this webinar, which I hope you'll find helpful. You may know that there were 55,645 private law cases started in 2020. I always find these statistics a bit mind-boggling, and sometimes I question whether they're accurate, but I understand that that particular figure is pretty accurate. It's also said, and I'm not sure about the accuracy of this, is that about 40% of those private law proceedings, particularly the child arrangements issues, were thought to involve allegations of domestic abuse. So if one looks at those numbers, particularly with regard to the allegations of domestic abuse, that's enormous, isn't it? And of course, the question of domestic abuse is very much in the minds of governments and also the judiciary. So many private children cases proceed through the courts without too many complications, so it's not all that bad. However, some cases produce challenging issues which confront us just occasionally, and we can find ourselves wondering what to do and how to handle these situations. So it's for this reason that I think that fact-finding hearings fall into this particular category. They don't come up that often, but when they do, in my experience, they're quite tricky. Fact-finding hearings arise, of course, where there is an unresolved issue of domestic abuse that could impact on whether contact, and I'm going to be focusing, of course, on contact, should take place at all. And that's very often where it arises. If contact does take place, can arrangements be made to ensure that contact is safe and does take place at least in some form? So when dealing with a private law application, and in particular a child arrangements order application, the court will make a number of assumptions, and I'd like to go through those with you. Now, this is still the position, even when one party makes an allegation of domestic abuse. So those assumptions still arise. So what are they? The first is that the court must make a decision that is in the best interest of that particular child or children. The second is that the court has a duty to promote contact with the parents in accordance with the child's rights to family life under Article 8 of the European Convention of Human Rights. The third assumption is that there is no presumption either way as to whether or not a child should have contact with a domestically abusive parent. And the fourth is that the involvement of both parents in the life of the child will further the child's welfare. But these presumptions, of course, are just a starting point and will not apply if the evidence shows that any involvement by the parent will expose the child to a risk of harm. So you can see that whilst we start off on the basis of normally contact takes place, it's good for the child to see the parent and so on. If there is a question of risk, then the situation could be different. Now, there isn't a presumption that if domestic abuse is proved or admitted, there should be no contact. But the court does have to look carefully at what the level of risk is and how it can be managed and what the possible advantages and disadvantages of contact might be. So you'll see that the court needs to exercise a balancing act, taking into account all these assumptions. How does it do that? Well, in doing so, the court has the help of a very significant practice direction. It's a pretty long-winded title, but it's Practice Direction 12J, Child Arrangements and Contact Orders, Domestic Abuse and Harm. Most of us know it simply as Practice Direction 12J, which sets out the points that the court should consider where abuse has happened. Let me go through those with you. Now, these are set out in a sort of, if you like, a bullet point situation. Now, of course, you can look at your notes so you can be refreshed by that. But first of all, we look at the effect of the domestic abuse on the child, where the child is living. The effect of the domestic abuse on the child in the relationship with the parents. Whether the abusive parent is using the process to continue a form of domestic abuse against the other parent. The likely behavior of the abusive parent during contact, and the capacity of the parents to appreciate the effect of past domestic abuse and its impact on the child. So the court would look at each individual case and see what is appropriate. In each case, the court still has to decide what is in the interest of the child. So what is the child's best interest within the case? And that will mean deciding whether contact is safe. In some cases involving domestic abuse, the question for the court is, how can contact be made safe? In other cases, the question is whether contact can be made safe at all. So when the family court has to make those decisions about the child's welfare, the court needs to know or decide what has happened in the past. Where the court has to make that first decision, then of course it looks at it and says, do we need to have a fact-finding hearing? Should it take place before the court makes an order regarding the child in question? Until the court has decided whether the allegations are true, it will work on the basis that it might be true and will put safe arrangements in place. This may mean no contact or supervised contact. So practically speaking, you may go to court and this allegation is raised, and the district judge or the circuit judge or the magistrates may turn around and say, we can't make a decision at the moment, to the frustration, of course, of, say, the father who's been desperate to see his children. But because of the safety aspect, no judge or magistrate is going to take that risk. So sometimes we have to advise clients that whilst it's not ideal, and in fact sometimes quite unfair, they may have to wait. If the court decides that a finding of fact hearing is needed, it will be required to put measures in place to bring this about. A fact-finding hearing is a court hearing that considers the evidence surrounding allegations made by one party against the other. You may say, well, that's self-evident, but it isn't always. The court needs to make a decision as to whether alleged incidents did or did not happen. Evidence is heard, which will normally include parties being cross-examined. After having heard the evidence, the judge or the lay magistrates will decide the matter. Most commonly, these allegations concern domestic abuse, but can relate to other aspects of behaviour. Domestic abuse can include neglect, emotional and physical harm, and violence. It is for the party making the allegations to prove that they are true. The judge or the lay magistrates will consider, on the balance of probabilities, whether it is more likely than not that the allegations are true. In preparation for a fact-finding hearing, the party making the allegations will be directed to serve a list of the allegations in the form of a Scotch schedule. Each incident should be numbered and set out in date order, stating the date of the incident and details of what happened and where, details of any witnesses to the incident, and the involvement of the police and medical service, of course, if appropriate. The person against whom the allegations are made will then be directed to respond to the allegations. The person accused should respond to each allegation in turn, setting out their account of the incident, or simply stating that the allegation is denied. Both parties will also be asked to make a written statement setting out their evidence. Witnesses can also make a statement and give evidence, of course, with the court's permission. How does the court decide which cases need a fact-finding hearing? When a private children case comes before the court, the application triggers a process requiring CAFCAS to carry out basic safeguarding checks. These reveal whether the family are known to the police or social services, or if the parents have any relevant convictions or pending prosecutions. CAFCAS will also attempt to speak to each parent on the telephone. That's, of course, before the first hearing, and check whether they believe that there are any safety issues. If a parent thinks that there are safety issues, they should raise these with CAFCAS during those decisions and before, of course, the court hearing. Now, sometimes a client will say to me, I am concerned about this issue. And I often say to them, make sure that you convey it to CAFCAS. They will listen to you. And most importantly, they will, of course, will reflect that in the report that they make to the court. Now, that report is a safeguarding letter, and of course sets out details of their inquiries which is filed with the court and providing the parties with a copy. For my part, and I've seen this develop over the years, I think safeguarding letters can be really useful. Useful for the parties and useful particularly for the court. So if there is a concern on the part of one parent against the other, particularly with regard to allegations of abuse, it's so vital that's communicated to CAFCAS during those discussions. Now, CAFCAS may recommend that a fact-finding hearing is necessary before the application is fully considered by the court. And that will be highlighted, of course, at the first hearing. What are the reasons for a fact-finding hearing? The decision about whether to hold a fact-finding hearing is for the court, not CAFCAS or the parties. At the first hearing, we rather describe it in very long terms as first hearing and dispute resolution appointment, but perhaps we prefer just simply FEDRA. The court has to consider Practice Direction 12J, that I've referred to earlier, which informs the court how it should approach cases involving allegations of domestic abuse. The thrust of Practice Direction 12J is that if disputed allegations would be potentially relevant, and that's important to consider, potentially relevant to the final decision of the court should determine the dispute by deciding whether the allegations are true or not. The decision about whether or not to hold a fact-finding hearing should be taken early in the proceedings, and preferably at the FEDRA hearing. The practice direction sets out procedural framework which should be followed by the court. It sets out factors to be taken into account when determining whether to make a child arrangement order where domestic abuse has occurred. When deciding the issue of child arrangements, the court should ensure that any order for contact will not expose the child to an unmanageable risk of harm. The court is required, in its judgment or reasons, always to make clear how its findings on the issue of domestic abuse have influenced its decision and on the issue of arrangements for the child. Practice Direction 12J can be downloaded in full, and I'd recommend that you do that. Do it tomorrow. Make sure that you're fully aware of the terms. Practice Direction 12J is not difficult to read, but it's free of charge on the internet, and it's certainly going to be helping you in dealing with issues such as they are. And have it to hand when, of course, something like a domestic abuse case comes into your office. If a party has been directed to serve or respond to a Scott schedule, a template form can be used. So you don't need to start from scratch. I have already set out details of what this contains and its style, but I would like to make particular mention of the role of the judge or the lay magistrates. They will hear evidence and decide whether they find each allegation to be true. If the judge finds that the allegation is true, he or she will state that the allegation is found. If the judge decides that the allegation is not true, the judge will state that the allegation is not found. If the judge cannot decide whether the allegation is true or not, the judge may state that the allegation cannot be determined either way. So you'll see that the evidence that comes before the court is dealt with carefully. Each party must prepare a witness statement in advance of the hearing. Usually the person making the allegations goes first. Each allegation or incident will be dealt with by the parties in their statement. Sometimes the court will place a limit on the number of allegations that should be included in the schedule. This is simply to ensure that the case is manageable and the fact-finding hearing is focused on the most relevant and perhaps more important issues. It's not common for a victim to, what I should say is that it's quite common, and maybe not uncommon, to set out a long list of allegations, so the court will need to go through a pruning exercise by asking the parties to reduce the list to say 5 or 6 of the more serious allegations. Again, practically speaking, if I'm acting for the person who's making the allegations, they will bring a whole list of questions or allegations into the office. I then have to spend some time going through them, trying to sort out what is important or what is perhaps less important. But the court will go through that exercise as well. And it depends on the lay magistrates or the judge concerned, but they will not want to go through each and every single allegation if it's a long list. And that's why I think, practically speaking, usually 5 or 6 is the maximum. Certainly that's the case in my experience. What happens at the fact-finding hearing itself? Well, the person making the allegations of abuse and any witnesses will give evidence first. The accusing party will confirm or indeed correct their witness statement and may then be asked questions by other parties, particularly the opposing party, the accused party. Sometimes the judge will ask some questions. The same process will take place for the person who is accused of the abuse and any witnesses he or she is brought to court. The parties will then be able to make submissions to the judge or to the lay magistrates. The judge will then announce a decision and give reasons for that decision. Now, this process might be adapted if one or two, or the opposing party has no lawyer, and we'll be looking at that in our second session. And the court makes special arrangements because of that. Whatever happens, it's important, particularly in sensitive issues to do with children, that both parties are treated fairly. And there is a complete focus on the interests of the child, as well as, of course, the fairness towards the parties. I want to say a little bit about possible changes. Fact-finding hearings have recently been the subject of some scrutiny by the Ministry of Justice and the courts. Whilst what I have said currently stands as good authority, there is the possibility that changes could take place at some time in the future. Following the cases in the Court of Appeal of Re HN and others, the full title is Re HN and others, Children, Domestic Abuse Findings of Fact Hearings. I know it's a long-winded title, but it was made in 2021 when the Court of Appeal raised a number of important points. It was, if you like, an amalgam of a series of cases which raised something very similar within each case. First of all, the Court of Appeal decided a number of issues, and the first one was that it was accepted, thankfully, that Practice Direction 12J remains fit for purpose in providing the courts with a structure on how to approach private law when allegations of abuse are made. The second was that specific guidance was given by the court in relation to a number of issues. First of all, whether there should be a finding of fact hearing at all, the use of Scott schedules, and the court's approach in dealing with controlling and coercive behaviour. The Court of Appeal also made it clear that the criminal law concepts should not be imported to the family court. I'm going to read just a couple of sections in relation to, first of all, the Scott Schedule, which I personally find this helpful. The court heard submissions from the parties as to the usefulness of Scott Schedules, and the court focusing on a list of specific incidents, each tied by time and date, rather than whether there had been a pattern of behaviour. The parties had also been required to limit the number of allegations to be tried. You remember when I started by explaining what a Scott Schedule is, that of course each matter is itemised. But the court concluded that serious thought is now needed to develop a different way of summarising and organising the matters that are to be tried at a fact-finding hearing. Quite how a move away from the use of Scott Schedule is to be achieved, and what form any replacement pleading might take, does, however, raise difficult questions. And the second point is in regard to controlling and coercive behaviour. The court said this: in cases where an alleged pattern of coercive or controlling behaviour falls for determination, and the court has made that issue its primary focus, the need to determine a range of subsidiary date-specific factual allegations will cease to be necessary. And so in many respects, if I was to paraphrase, the Court of Appeal was saying that it may be that the Scott Schedule system of individual allegations may come to an end simply because it doesn't address the issue of a pattern of behaviour, sometimes under the heading of controlling and coercive behaviour. So it should be stressed that this guidance given by the Court of Appeal in these cases has no formal legal authority at present. But it's likely that changes will be made on these issues in due course. A couple of other cases, in the case of F&M, which is 2021, again set out in the notes, the court spent some time focusing on coercive and controlling behaviour. More recently, in the case of AA and BB, 2021, so it's really up to date, that involved a private children proceedings case. This case is one of the first reported cases to consider the implications of Re-HN. In that case, the appeal was against a case management decision to exclude evidence from a fact-finding hearing. You remember when I said earlier about the courts often want to cut down the number of allegations. In this case, the mother relied on the dicta of the Court of Appeal in Re-HN regarding the limitations of Scott Schedules and the fact that the court focused on particular allegations rather than looking at patterns of overall behaviour. So let's summarise what we've looked at already. So in an application for, say, a child arrangements order, and in particular maybe contact, but it could of course embrace other issues, CAFCAS will carry out their checks and report to the court. In that report, there may be issues of domestic abuse raised by the parties, raised by even a child, although it's likely to be that the child isn't even consulted about these issues, but it may come from a different source, maybe from social services, for example. The court will then decide if a fact-finding hearing is necessary. If the answer is yes, directions will be made for a Scott Schedule, the response and the statements by the parties. A hearing will then take place when both parties will give evidence and be cross-examined. The court will then decide on whether the facts are true or not and give reasons for that decision. A further hearing on the application itself will then take place, probably on another day. But in the meantime, there could be further directions needed, maybe a Section 7 report to explore the issues in the light of the court's finding. Then, of course, the court will decide on the issues as a whole, hopefully to bring matters to an end. So that's taken the first section of my presentation. We're now taking a break for tea. And when we return, I plan to look at fact-finding hearings when a litigant in person is involved. Thanks very much.
Thank you so much. And we'll be back in, let's see, have we got 15 minutes, I think, for our break? And goodness me, you are spot on time. I take my hat off to you. We'll see everyone at, you get the award. There should be a gold star.
Thank you, Constance.
15:50 to 4 o'clock.
I'm not used to having awards, so it'd be a nice one today.
A gold star for you. Okay, everybody, looking forward to seeing you in 15 minutes.
Thank you.
Some litigant in person. So help us.
Thank you, Constance. Thank you.
Tackle that one.
Well, welcome back to this second section of my presentation on the question of fact-finding hearings, particularly focusing on the question of cases involving litigants in person. Now, as you will probably know, in the way that I've had experience over the years, I suspect you have too, in knowing that litigants in person appear in family proceedings on a regular basis. And it's particularly the case in private children cases, because of course there is a lack of legal aid, in fact, virtually no legal aid, unless of course there's domestic abuse, in which case legal aid certificates are only granted to those who are the victims of domestic abuse and not any other party involved. Certainly that's the normal experience. But you'll know that many private children cases do involve at least one party not having legal representation. I think it's fair to say that statistics are in short supply in terms of how many and how often. But the latest figure that I've seen is that something like only 25% of private children cases have both parties legally represented. Now, if you're a solicitor or counsel involved in those sorts of cases, you will have come across perhaps cases where you're representing one party, but your opponent has no legal representation at all. Now, just to show how frequent it is that I had a discussion with a legal advisor just before lockdown, who told me that it was rare in her experience in private children cases before lay magistrates that both parties are legally represented. So the idea of only 25% being represented doesn't seem far out. If that is the case, the court needs to think carefully about how it handles cases where one party, often the victim, is represented and the alleged perpetrator is a litigant in person. In my experience, a number of issues arise. The first is making sure that the correct issues are put in writing before the court, including the Scott schedule and the witness statements. For the litigant in person, this is not always easy or indeed straightforward. And there can be real difficulties in making sure that the paperwork and the evidence before the court is clear from the outset. The second is guiding a litigant in person at a hearing with which he or she has no experience, whether they should give evidence or not. And so often we go before the court, they seem to be completely unaware of what's involved, but perhaps more importantly, what the choice is in terms of giving evidence at all. The third is making sure that the litigant in person understands the significance of the findings. Because, of course, if the court came to the conclusion that there has been domestic abuse, it could impact immensely on his ability or her ability to see the children. The fourth is allowing the litigant in person the opportunity to cross-examine the other party who may be making serious allegations against him or her. And the final point, a fifth point, is ensuring that the litigant in person obtains a fair hearing. And of course, that takes into account all the points that I've made already. Now, my own experience is that it does depend on who hears the case. Many district judges are experienced at handling litigants in person and ensure that there is fair play. They seem to go out of their way to make sure both parties are heard well, will take up questions for cross-examination and ask them on behalf of the litigant in person. Lay magistrates, certainly in my experience, are not so good. Much will depend on the experience of the legal advisor. They tend to be less proactive. And sometimes the litigant in person can be left to their own devices on occasions. Now, if we take into account the fact that many straightforward cases involving children go before lay magistrates, then of course it's a worrying feature. I dealt with one case where the legal advisor took what I'd describe as a minimalist approach, failed to advise the litigant in person fully, which had a detrimental impact on his case. We do, of course, try to correct the position as best we can, but there are, of course, limits as to how far we can go. We do have a duty to the court, but we also have a duty to our client. So we expect the court to do the business, as it were, and ensure that there is fair play. So it's always concerning to me, particularly before lay magistrates, whether litigants in person do have a fair hearing. The more proactive approach on the part of the court, as well as advocates, does carry its dangers, of course. And I'm going to illustrate that with a number of cases shortly. But I'd refer you to a book that you may or may not be familiar with, but I know Micheal will because of his experience as a judge, is that there is a book called The Equal Treatment Bench Book. And that's a book that gives advice to judges, and I suspect lay magistrates, as to how to deal with a case. It's a very comprehensive piece of work. And interestingly, it is available on the internet, and I've often referred to it in relation to certain aspects of a case. But according to the most recent version of the Equal Treatment Bench Book, at any court hearing, a judge should aim to ensure that litigants in person understand what is going on, what is expected of them at all stages of the proceedings, before, during, and after any attendances at a hearing. And this means, and then a whole list of things is given in terms of advice to whoever's hearing the case. The process is explained to them in a manner that they can understand. In other words, the litigant in person. That the litigant in person has access to appropriate information, rules, practice directions, and guidelines, whether from publications or websites. That the litigant in person is informed about what is expected of them in ample time for them to prepare and comply. Wherever possible, they are given sufficient time for their particular needs. Judges must be aware of the feelings and difficulties experienced by litigants in person and be ready and able to help them with the court process. especially if a represented party is being oppressive or confrontational. Maintaining patience and an even-handed approach is also important where the litigant in person is being oppressive or confrontation towards another party, or their representative, that could be you, or towards the court or tribunal. The judge should, however, remain understanding so far as possible as to what might lie behind their behaviour. Litigants in person commonly feel at a profound disadvantage. The aim of the judge should be to ensure that the parties leave with the sense that they have been listened to and had a fair hearing, whatever the outcome. So the key is to maintain a balance between assisting and understanding what the litigant in person requires, while protecting their represented opponent against the problems that can be caused by the litigant in person's lack of legal and procedural knowledge. Most judges acknowledge that dealing with a case involving a litigant in person, and I would put fact-finding hearings in the midst of all this, can be a challenge. More often than not, the judge treads a fine line between making sure a hearing is productive and worthwhile, while at the same time ensuring that the unrepresented party has a fair and proper hearing. So you can see that there is a massive responsibility on the courts to make sure that both sides are treated well and fairly and in the interest of justice. And it's not always easy when you have a litigant in person who's accused of doing certain things which he or she adamantly denies and feels very strongly about. A litigant in person is expected to comply with all the court rules and procedures as confirmed in Barton v. Hasan in 2008. But there will often be a need to take a more flexible approach in family cases, as stated by Lord Justice Mumby in the case of Rees C in 2012. A fairly recent case in the Court of Appeal revealed that a judge can go too far in attempting to direct the case in a particular direction in order to assist the court process. So we have a difficult situation. You are representing a party, you have a litigant in person, or maybe you're sitting as a judge and you're having to deal with what can only be an unequal situation. You have one party is represented, another party is not only unrepresented, but probably has absolutely no idea of the process. And it's very difficult. So put yourself in the situation of the judge, and how does the judge deal with it? I want to talk to you about the case of Regina v. Inkster, which is 2020, where the Court of Appeal was satisfied that the circuit judge's uninvited intentions and the consequent impact upon the unrepresented appellant, and these are the words, created inappropriate pressure on the appellant's freedom of choice. The appellant had pleaded guilty to 3 counts of breach of a non-molestation order and was sentenced to a conditional discharge for 6 months. Now you may think, well, if he's in breach, it's conditional discharge, nothing particularly serious about that. The primary ground in the appeal was the appellant's decision to change his plea and whether it was a voluntary choice. Remember, he's on his own, he's being talked to by the judge. The pressure placed on the appellant by the judge resulted in the appellant feeling he had no choice but to plead guilty. The appellant was unrepresented at the hearing in the lower court and argued that he was in an unfamiliar environment, which of course he was. At the appeal, it was suggested by the Crown that the appellant was an intelligent and articulate man who chose not to be represented. He understood the process and engaged with it. He understood the law and was capable of representing himself. The Court of Appeal rejected these arguments as the trial judge had effectively advised the appellant as to a particular course of action. So the moral of the story is that a judge must exercise his or her role with great care when dealing with a case involving a litigant in person. The judge in this case appears to have attempted to assist the case by expressing his view in such terms that the unrepresented party felt that he had no choice
He didn't use
to follow such advice.
the full wherewithal that was at his disposal for the first 4.
Sorry, was there some interruption there? This was clearly exceeding his role, and such intervention proved to be incorrect in law. Another aspect of this case was the involvement of counsel for the Crown at the first hearing. He volunteered to speak to the appellant during the luncheon break and act as a wise ear. Counsel appears to have given advice to the appellant, which may have led to the appellant to believe that he should follow the judge's indications. He seems to have done so with every good intention. That is, to assist the court as well as the appellant. The Court of Appeal took the view that by meeting with the appellant, counsel may have made the situation worse. So you can see it's a difficult situation. The judge felt probably that he should have done something. He was trying to help him, helping the litigant in person to make a decision. It was then, of course, assisted by counsel for the Crown, who said that he would help too, and by trying to help, overstepped the mark. Whilst that case is a criminal case, the principles in handling a case involving a litigant in person still stands. And I think it would be something that we need to look at. So relating it to a situation with a fact-finding hearing, put yourself in the position of the judge or the lay magistrates, the legal advisor. Maybe put yourself in the situation where you're trying to help, but by doing so, find yourselves in difficulties. So it's something that you have to think of very carefully. Maybe as a representative of a party, how far do you go? Do you simply distance yourself and take no action at all? Or do you try and relate to the litigant in person, say in a fact-finding hearing, only to find that, if you like, it backfires? So we do have to be very careful. But these situations are very real because we have so many of them. Another case that came before the Court of Appeal recently is the case of Ria and Ria, actually this year, where two unrepresented parties had contested what was described as a genuine mistake by a deputy master in restricting them from cross-examining their sister, the respondent, during a trial in September 2019. This was a challenge over a will. So you tend to think, well, that has nothing to do with me, but it's interesting to read this and how it impacts on the issue of a litigant in person situation. The first appeal was dismissed by Mr. Justice Adam Johnson, who ruled the deputy master had sought to assist the appellants at trial by being flexible and adopting an inquisitorial role. The court heard that the deputy master questioned the respondent on a number of topics raised by the appellant. When they indicated that they wished to raise some questions themselves, he intervened after 4 questions to stop those which he considered irrelevant. Civil litigation in England is not conducted by the judge on an inquisitorial basis, said the appeal judge. The fundamental importance of the right of a litigant to cross-examine an opponent's witnesses in an adversarial system has been emphasized in many cases and is the foundation for what has been termed the core principle, that the judge should remain above the fray and neutral during the elicitation of the evidence by the parties. Lord Justice Snowden said that there was a world of difference between a judge taking steps to assist a litigant in person to put their case to a witness for comment, an effective cross-examination designed to extract admissions. He cautioned against judges acting as a quasi-advocate for a litigant in person, and said that while the rules allowed a judge to put questions to a witness, this should not be on a free-range basis. He added, the suggestion that the judge might adopt an inquisitorial role can be understood as a suggestion that the judge might actively question the litigant in person during the openings at the start of the trial, simply as a means of teasing out what the litigant in person's case really is. But this has nothing to do with the judge acting as an inquisitor of witnesses during the subsequent evidential phase of a trial. So if one takes into account all that we have considered today, one will see that the fact-finding hearing can be a real challenge. First of all, factually, we have a lot of private proceedings involving a litigant in person. We then have to move on to the question of what sort of problems arise as a result of that. Remembering, of course, the judge has a responsibility to make sure there's fair play, make sure that all the facts come out. But in a situation where you've got a party who has no experience or knowledge of how the system worked. So it is a balancing act. So when we, as solicitors or counsel, go into a hearing, it's certainly my recommendation that we do so, especially in a fact-finding hearing involving a litigant in person. We do so with great care and with a good dose of caution. We do want to help. We want to be correct as officers of the court. We want to treat the litigant in person well and fairly. But we do have to think carefully that we don't get ourselves into difficulties when representing our clients at court during those situations. Many thanks for your attention this afternoon. Thank you.
Thank you. That is very useful. I know I've been involved in a pro bono case, and I know that the pro bono chap was a litigant in person, and I saw the directions that had been given to him by the court, and it said you must submit your questions in advance. You won't be allowed to cross-examine on the day. And it seemed to me quite a lot to ask a litigant in person to know what needs to be asked. It seemed to me that was way over a fair hearing. I mean, the equality of arms jurisprudence seems to have gone out the window. But yes, thank you. That is going to become a bigger and bigger aspect of what is going to go on in court. I do think that the whole business of facing up to just how many potential fact-finding cases there are was just overwhelmed the court, and in a sense that making of the fact find being necessary really was just the only thing they could think to do. I did find the allegations against him in this pro bono case fascinating, because one was that he had read her diary, and another allegation was that he had photographed her when they were being intimate together. And there were a few others, but I just thought, you know, I certainly, it was very difficult to feel much sympathy, but I didn't quite see what the relevance would be of that kind of allegation, which takes place between the partners, the couple, would have on contact. And I was very interested to just follow that through. I don't know, is that the sort of thing that you meet when you put these things into a Scott schedule? They also sometimes seem so much less alarming than they do in the midst of a very emotive witness statement.
Yes. What troubles me particularly is that, and we've looked at it to some extent, is that the courts are overwhelmed with work at the moment.
Yes.
Which means that a lot of children cases, child arrangement order cases particularly, go before lay magistrates.
Yes.
I'm never uncomfortable about a litigant in person before a judge. I usually find that judges are really good with dealing with them and really go out of their way, as I mentioned earlier. Once you're into the lay magistrate's position, really, I'm not entirely sure whether the courts are that interested in helping litigants in person, but that's just an impression that I have.
Well, it's interesting to hear you say that, because the same thought has crossed my mind. Well, we are now going on to the panel discussion, and we have a little time for that. If there are any specific questions, I think we're still in sync. 1600 to 1630 is available for a panel discussion. We have a little gap. I'm interested to know if we have got, let's see, there seems to be a question that's come up in the box. Ayesha, could you possibly give me your lecture notes so I can, oh, that's not right. That is me asking you if you could possibly give your lecture. So, and you very kindly did. Here we are. So I'm just looking for anything that looks like a question.
I don't think, Constance, we've got any questions at the moment. I think.
Yes. Well, I think we've met every need. That's the quality of the speaking that's gone on.
I think we could ask each other questions.
Law.
Yes.
We could keep it going for a while and ask each other questions if we've got any.
Goodness, yeah. Well, that's
Can I ask Michael?
I think we're sort of obliged.
Stuart's got a question.
Constance, can I ask Michael, drawing from his experience on the bench,
yeah,
how he dealt with litigants in person and whether he found it a challenge?
Possibly exhausting. When you are actually dealing with them, the adrenaline turns on. It becomes actually quite exciting. You haven't got the filter of counsel. You can get straight there.
yes.
Every now and again in a children's case, some judges perhaps naughtily say, well, can I, if Miss Whippman will allow me, can I address mother directly? And what you shouldn't. You feel you're cutting through. You do feel you're cutting through, but it's utterly exhausting. And there's one other thing that is a huge burden. You have to draw the order. There's no one to help you.
Well, let me tell you the latest,
Michael. You've got twice the work. I don't think the customers understand this. Normally, with any kind of representation, you can say, well, please send me in an order for me to correct or to approve. But you've got to go through and put everything in yourself. It's double the workload. You can see why the system is clogged up. But on the other hand, you ask yourself, if you were a rising young star in the Treasury, looking over the court system, wouldn't you be asking, why should the state pay for people to decide whether their children are shared on a Saturday or a Sunday, or which petrol station they meet at? So you can see why we're in this mess. And of course, remember, particularly contact, golden rule, it's never about the actual issue of contact. It's unexhausted business between the parents.
Yes.
Yeah.
So it's desperately difficult.
But
the
Michael,
other thing
I have a question.
You have to be terribly careful that you don't get a judicial complaint, because one false question, one exclamation or something, and you know, the dreaded letter will come, and usually when you come back from holiday, saying there's been a complaint. So it's a terrible burden.
Michael, you've mentioned something that's
mediators. In a much less deferential society, that's the other aspect of it.
Yes. Ayesha.
Yeah, Michael's mentioned something that really is a bugbear to me. When I started at the bar, which is like you, Constance, I'm quite old in this game now, slightly. But Michael knows, because he's even, you know, he was sitting at the time. Judges used to articulate what the order was. The clerk in front used to draft. It wouldn't be more than one page. And it would be just, this is the order, and that's it. And it'd be drafted, and we'd go out. Now, exactly what you've just said. You've said litigants in persons, one of the problems and the downside, we have to draft the order, the judges. But that is the judge's function. Why is it now for the lawyers to draft the orders, and we spend hours emailing each other? And if we're in a care case, 5 advocates before the order gets back to the court. And then again, we've got to try and agree it, and we have arguments. Why can't the judge just draft his own order?
Yay.
That's what their function is.
Because it's incredibly complex. I mean, take a financial case. An old-fashioned financial thief, he pays her £30,000 and maintenance £400, 9 shillings and 6pence for 10 years. Now the recitals and the dealing with this and the dealing with that and the exclusion of that and the transfer of that, they're enormously complicated things.
Yeah, I do remember those golden days when the judge used to draft the order. But I was very interested to discover something new and that I didn't know about drafting orders, which is their guidance. And I don't think it's in the bench book, because I have looked at that. It's a very, very interesting resource. But there is other guidance tucked away that says that the litigant in person should be consulted before the order goes back to the judge. And of course, they tend to want to renegotiate or to fight the same battle again. And it is very difficult to do. And the particular pro bono case that I was asked to come in fairly late, I looked and tried to think what on earth had gone wrong. Because the orders were so mixed up, and there'd had to be 2 applications back to the judge to vary and so on. And that was simply because counsel for the one party had refused to talk to the litigant in person, who, which I was surprised by, because the actual guidance says that, and the judge had said, no, you don't have to check with the litigant in person. So he was also unaware of this particular provision. I'm going to pull that out at some time in the future.
That's very interesting, Constance, because at the end of the day, how do you negotiate an order with a litigant in person? First of all, I don't really want them to have my email address.
Well, that's a pain. And the way you do it, if you're counsel, is you get it, it must be sent through the clerks.
Yes. I mean, we can get around that.
But it is difficult. And of course, when you say negotiate, you've used exactly the right word, because that's what they think they're doing. Whereas what you're doing is recording the order that the court made, not making it up to be either in your client's favor or in the other side's favor. But it is a very artificial concept, and it is hard with litigants in person. It's hard enough with counsel, who can be very difficult. I mean, usually you kind of get there. They went through one phase where we were still having live court hearings, where judges wouldn't let you leave to go until the order had come back to them, and they'd seen it. And it tended to mean that you would get paid, because that time would be added to your, to your FAS form if it were care proceedings. So. But I have noticed over the years, first the judge stopped doing the orders, then you had to do the skeleton argument, but you couldn't include that to be paid for it. And there's been just an awful lot of additional work that's been loaded onto councils. It used to be that you'd send your list of authorities off to the Court of Appeal, and they would go and get the books for the 3 judges. Well, those days are over. You have to photocopy everything, and on it goes. It's and a lot of the old courtesies have been left, so that you rarely find that somebody is giving you a list of their authorities where you've actually got a legal point ahead of time. They tend to produce it, and that was always considered very bad form, and rightly so. You needed to have an opportunity to think about it. But yeah, I've now reached the advanced years where I'm saying it wasn't like that in my day. But that's a sure sign you're getting old. But what an interesting day.
On the question of
sorry, Stuart, after you.
Doug, well, I was just thinking about the situation in court where you have a litigant in person and you do negotiate terms, say over the issue of contact.
Yeah.
It wouldn't necessarily be a fact-finding hearing, but it could be to do with just the level of contact and so on.
Sure.
And it's certainly my practice is never to leave court until you're absolutely sure that you are agreed and the order has been made by the court.
Yes, absolutely.
Leave it. You have this real difficulty of, as you say, they'll start to challenge the content of the order. And this is where I think the judges can be really helpful on that.
Oh yes, you have to go back in, and this is even if it's in pencil in your blue book or something, to have the judge approve it. But if you're the last case in the day, it sometimes be quite a challenge,
I think they're two very important points. First, do not underestimate the importance of drafting the order. In the old days, it was a general blah. He will see his father twice a week on Sundays or something. But now the detail is important. A family, a parenting plan, or whatever the current label is, will be often be very detailed. And to go back to financial issues, there is so much detail that is required to be put into an order, dealing with bank accounts and with pensions and recitals and undertakings and acknowledgements and so on and so on. The devil is in the detail.
Oh yes, you're right.
And if you've lost a case, you can recover some of the graft in the drafting. You're likely to get into trouble with your instructing solicitor if you're a barrister, or with your client if you're a solicitor, if you've been cavalier and just, oh hell, I've worked on this case all weekend, I've fought till 6 o'clock, I really can't be bothered with the nuances of the order. That disaster lies there. Second, don't underestimate litigants in person. In many ways, they know their case better than anybody else in court, because they've been obsessed about it for months.
Yeah.
They have a better grasp of detail than you have.
Yeah.
And they'll often spot points of detail that you haven't spotted. And third, the answer to it's now 7 o'clock and I want to go home, and the alarm has gone off at First Avenue saying, please leave the building, sometimes can be to agree a memorandum of understanding or heads of agreement, certainly between professionals. Here are heads of agreement. I'll send you my draft of the final order tomorrow or Friday or whenever it is. But nail, you're absolutely right, Stuart, nail something down. Don't leave anything inchoate or ambiguous as you leave the building.
That's very wise advice. Very wise advice. I mean, there is a pleasure in drafting an order well. I like drafting, and to feel you've actually got it down. That is good. I have had a policy in doing financial cases, particularly back in the days when there was public funding, to simply say, I'm not prepared to argue about chattels. I mean, we'll provide for you to come back before the court, and you can do it in person, or unless that there's some major issue about chattels. But once you start on chattels, you get 6 of them. I've actually had a couple that were really a high conflict case who were arguing over who could keep the wedding photographs, and that's when I introduced this mental policy. I would do everything else immaculately. Always provide for chattels to come back to the judge, and they did. Or I've suggested, let's flip a coin and see who goes first. You each choose alternatively. And
Constance, let's ask the audience. Let's ask the audience who are listening to us, if they have got any questions now to ask us, to please use the chat function and put their questions there, because they may have thought of something whilst we've been chatting away.
Absolutely.
And they might have come up with something. I've just been asked to remind them to please use the chat function if they can, to, ask whatever they wish to ask on topics that we've spoken
what
on.
we were saying beforehand, while this comes up, is that I know that AstenJ is going to look into seeing whether we can actually see the audience and let them unmute themselves. Everybody's very used to this now and knows how to mute and unmute. And it is nice to see a face. And
I find it very difficult to talk to.
It's very hard to put a question in a legal question into a chat box. So
I agree.
On chattels, my worst ever experience was drawing. We decided to negotiate chattels in the corridor after the decision, dividing. I promise you this was true. How do we split the cufflinks of their daughter who died of leukemia in her first year at university? She wanted both. He wanted both. They wouldn't accept the left cufflink and the right cufflink. But there is a neat technique that Lovely is such a reasonable man. Richard Sachs, who used to be at Manchys, had. You've got the list, and you just take it in turns. You throw a coin, spin a coin for who has first choice.
Yes.
And you go through the list, your pick, your pick, your pick, your pick, and you leave them to it, because life is too short to negotiate over ashtrays and cufflinks, and which get over-invested.
Oh, yes.
But the Sachs technique works.
Yeah. I had a recent case, an Asian marriage, where after the breakdown, he wanted the engagement ring and the wedding band back. And she said she left it in the home when she left.
Oh,
yeah. No, I haven't found it.
Oh,
so
yes.
he claimed that.
Have I heard that?
Sorry?
I've heard that many times.
And
that's
in
the trouble
end,
with the list version, of course.
The list version.
That's where the list can go wrong.
Yeah. Jewelry, Asians and jewelry.
Is difficult. And the lesson that every Asian woman needs is take the jewelry with you when you go.
It's always with the mother-in-law.
Yes, yes.
Because the minute she got married, mother-in-law stripped her of all her jewelry that she wore in the wedding pictures.
Yeah.
And the payback is one day she'll be a mother-in-law, can do the same.
She can do the same.
Wait 20 years.
Oh dear. I mean, these things are never about the things, are they? They're always about the subtext. But I think it's so sad to end on your example, Micheal, that I will give you a less difficult and painful one, which is I acted and got a final order in relation to a Inheritance Act claim. And the solicitor who was going round to do whatever it was she was doing at the house to finish it off, texted me, there were no texts then, but told me that they had actually got to the point where there was a very, very large box of Persil, or whatever the soap powder was, and they did it scoop by scoop for the two sides of the family. And I always thought that must be an absolute low ebb, where you find yourself dishing out Persil powder to be sure that each got half of this large box. So but that's the human condition, isn't it? Here we go.
having difficulty in downloading the notes.
Oh.
That's something that probably Aston will have to sort out.
I think that's going to be,
Oh.
yeah, I'm afraid, do you know, I think if you email, can I just, let's see if we can get your name and we can pass this on just to be sure that.
It's H. Denise Pinder.
H. Denise. Yes.
I thought, Constance, they were going to send all the notes out to all the attendees.
I thought that they did, but if it's trouble downloading, it must have been received, but opening the file. Could anyone else who's managed to open the file perhaps put into the chat box that they've managed to access the material, or maybe we've got a more general.
Aston says we will look into that. Ask them to look in junk. I'm not. I think they have received it. Your point is correct, Constance. They can't download it. So Aston says that they will look into that.
Okay.
Somebody else says I've accessed it with no problem. Shabana says I've got it. So
Yeah.
it might just.
I was able to download it this morning.
I've been following it also to download it. So yeah.
Well, do you know, it's unusual for us to end early. I'm just wondering if it might be worth just seeing if I could ask each of you, to give us all, say, your top 3 tips on how to prepare a case. How do you tackle that? Is anybody prepared to go first?
I'll go first. But I think it's very individual to each person, how they like to tackle cases and how to prepare cases. I mean, nowadays, if you're getting a bundle of 1,000 pages,
yes,
it's very difficult to digest all that digitally and try and have it all, the facts under your belt. So depending on what the hearing is listed for, I think you need to target the relevant orders that you need to read. Because I do remember when I joined Chambers, the apocryphal story of the solicitor who went into the witness box and was being cross-examined and said, the judge asking him, did you not read that the order says blah, blah, blah? And his famous reply was, my lord, I don't read orders. So I think a very good starting point is read the last order at least.
Yes.
And then you know where to go from there. So it's depending on what the hearing is for, what is listed. You have to tailor the amount of time you've got to do all your position statements, advocates meetings, if that's what's necessary. You need to organize your time effectively.
Yeah.
So
look for that order
and prepare that.
Look for the order that allowed you to do more than 350 pages. And
can I go next then?
Yes, please.
But I have to declare an interest that I've actually written a book on the practical guide to advocacy in family proceedings.
Oh, here we go.
And
okay, good.
So to some extent, I'm trumpet blowing really. Is that and I picked some of these up from counsel over the years, so I don't. These are not my originals. First of all, I've said here 4 pointers. You talk about pointers. 4-point preparation is essential for every hearing, even for short and interim hearings. Secondly, be clear about what orders you're asking the court to make.
Yeah.
The next one is you have the evidence to support your client's case. And finally, ensure the court bundle is prepared, filed and saved in the correct form and in accordance with the court rules.
The bundle's the pain of my life.
Yeah,
I never have a bundle.
Ayesha, that I think probably as an advocate, it's the most important part of the case, isn't it?
Absolutely, Stuart. I get a bundle and I have to figure out who am I acting for.
Oh dear.
No one's told me.
Oh.
So I have to go through all the orders and by process of elimination, see which solicitor was acting for which client, because that's how briefs come nowadays.
Oh, wow.
Bundles are just forwarded across like conduit pipes.
That's right.
And they forget to tell you, oh, by the way, you're for the second father.
I love it when I'm for the second father.
That's a good one. That's a good brief.
I'd have 2 tips.
Okay, here we
One
go.
is one tip. There's a risk if you're rushed for time that you don't read the latest stuff. You touched on this, Ayesha. If you're really stuck and it's 2 in the morning or something, read the last letters and the last orders at least, because they'll lead you back. Nothing's more embarrassing than to find out, oh, no, that was all changed last Friday. The second thing is absolutely chronology is the key. Master the chronology.
Yeah.
If you have the chronology, you've got you can make chronologies using the sort function in Excel or in Word. And as you go through the papers, I would just type in relevant dates.
Yes.
And then press the sort button. So you're always updating the chronology. If something happened after something else, it can't have caused the first thing. And if you've got the chronology, you understand the structure and you've got an instinct. That can't be right. It didn't happen like that. It must be that. If you've got your own person, if you've got your own, yeah, sorry.
Michael, Constance, how will the transition phase divorce in general and the divorce with no fault?
Yes. Well, do you know, I hope that someone would volunteer to do a lecture on no fault divorce, because of course it starts on the 1st of April. But unfortunately, nobody did. There are transitional provisions, and what I would recommend that you do is, with the facts of the case you're dealing with clearly in mind, go onto the government website. And I think they make it as simple as it can be made there, because they say if you file before a certain date or after a certain date, this is what you have to do. Unfortunately, I haven't actually prepared it, and I would need to go quickly to see what those transitional dates are. But for once, they are very clearly set out. And of course, the delays that are inbuilt into the new no-fault divorce are very significant and will often slow things down almost to the level at which you know, it can be as ponderous as waiting to get the divorce process through the courts under fault provisions. So it is going to, there's reflection time there. You still have to wait a year before you can file for divorce. In other words, the more hopeless the marriage was at the beginning, and the more you need that divorce, you still have to wait a year. And when you raise such an interesting theme, Michael, on on what basis does the state interfere with what is, and perhaps ought to be, a private agreement between two people, if you take a different model of marriage. I often think that the hoops that you have to jump through, even the no-fault hoops, are very bureaucratic and unnecessarily so.
Well, that's always, that's the great English, the real English vice. Everything has to be gold-plated, a Brussels directive, and so on. The sentencing handbook, when I used to sit as a recorder, was, I think it was 3 volumes, loose leaf volumes. I'm sure it's 5 or 6 now. The guidance on sentencing for sexual offences, I think, was 140 pages, and so on and so on. So obviously there is a technicality to be mastered. I'm sure we all will. I'm a heretic on this. I've never understood the fuss. There may be a small minority of cases where people are desperately aggrieved by what he says about her in correspondence or in the petition, but nothing to what they said about each other in real life. I've always felt that I don't understand where the argument comes from, that it's such a major reform. I used to say when people were arguing about procedure, come on, divorce in reality in modern life, divorce is a partnership terminable at the will of either party at any time. And that's the reality.
Yeah, true.
And pieces of paper and what they say about each other on paper, I honestly think it's an overstated fuss, but other people think it's important.
Yeah.
Well, you're going to be relieved of this. As of the 1st of April, there will be No more fault divorces.
Sirajam wants to know how COVID has changed the family law practice. And are we going back to pre-COVID days?
Goodness. Who would like to go first on this?
Okay,
I welcome
I'll go
having live
first.
hearings. What is your view?
My view is that certainly the family law practice from me personally has changed significantly, in the sense that we're now much more dealing with interim hearings, directions hearings, I mean, to a very large extent, even final hearings on CVP platforms and MS Teams. And I think moving forward, we're going to learn from that we are not going to be freaked out when we are told we've got to get a witness from Kent to be on the video link, which once upon a time in the First Avenue,
yes,
you'd completely freaked out how to link that person up. We're going to move to a situation where there'll be more hybrid hearings. So I think COVID has had a huge impact on family law practice, and taking it forward, we can't ignore the fact that, we don't have to schlep all the way to Liverpool to do directions hearing when there's a video link available.
Yeah.
So I think some of the points will be there to stay. Some of the hearings will be there to stay, but I think the guidance we're getting from the president is very much now final hearings, FDR hearings, certain important hearings all have to be in person. And I think that must be right, because if you're having a final hearing in a financial case, it's very important that you cross-examine in person, you see the person, the judge gets a better feel of the case too. And it's only unless the court decides otherwise, will it be a remote hearing. So I think there's going to be a balance.
Yes, I speak from somebody who practices in the provinces, and I think there was some confusion initially by the president, because I think it was announced that we were returning to face-to-face hearings, and then it was corrected by saying we're returning to face-to-face hearings in London, the Royal Courts of Justice. I think in the provinces, it's been left to the individual courts. My own view is that it's going to be a slow process. I've had the benefit of doing stuff remotely, and life is a lot easier procedurally, but when it comes to the actual final hearing, I'm always concerned. I'm always concerned that I've had a number of face-to-face hearings. That's largely because I've been concerned over the judge hearing the evidence and so on. So, but I don't think we'll turn the clock back. I think there'll be a lot of hearings which will be by remote, partly because judges like it.
Have you done any arbitrations, Michael, by remote or by?
Yes, I've done one. I've done a mediation by remote, and because I was using rather primitive technique, I couldn't get them both on screen. I'd ask them on their honor to go out of the room while I talk to her direct and then to him. And I've done an arbitration. I think procedurally, directions hearings and discovery and for that sort of thing ought to be remote. Two points though. It isn't just looking at the participant and getting the visual clues. I mean, you're seeing me in a little size of a cigarette card, and it's not a very good picture. It is a good picture. You're not reading the face without knowing it. You're missing watching other people. I mean, in court, you get information for watching her while he talks.
Yes.
And the second aspect is what we miss desperately is our own collegiate lives. I mean, being in chambers, an enjoyable part of practice was making friends, and sometimes you got on better with some people than others in chambers, but you had a gang of people you could take advice from, pick up tips from, run little points past, go off to lunch with people in other chambers, solicitors talking to their partners and talking to their assistants. You can't do all that remotely. It's a great system, remote working, for people who are already established, who've got their houses 30 miles outside London, and it saves the commute. It's a terrible way for younger people to pick up how to be in a terribly complex profession. And
Yes.
that's what I think is desperately being missed. Heaven knows how you do a training or pupillage now.
I'm concerned about that, I have to say. I am concerned about
We
that.
had to send our pupil effectively to shadow us online. So when the links were sent out, we sent it to the pupil so the pupil could see how it was being done.
I know.
It's
But
not
you
satisfactory.
10% of what it is to be a lawyer.
I know.
And how to behave well, and when you're behaving badly, and when you're making mistakes. You don't do this by remote. I conduct very efficient committee meetings, and committees I'm members of, where we know each other and we've got an agenda to get through fine. Zoom's terrific for that. But for any subtleties, no.
There are just the simplest things. For example, when you're in person, one of the first things you learn is to watch to see if the judge is still writing. And when the judge stops writing, but you can't tell whether they're writing or not when it's a Zoom meeting. And I mean, that is just the simplest example of it. But it's that reading of the room that is just so critical. You can tell when people are bored. You've said it, they've got it. You can, and that is very hard to know. I loved having or learning those skills over the years, and I didn't feel the quality of justice when you couldn't be in the same room as your client. How do you negotiate effectively? Because so often at court, you can say, look, can we have a word about this? Is there any chance of moving forward or whatever? That informal input into helping things move on is just utterly lost. And I could easily live happily to the last of my days without seeing another digital bundle. I miss paper. I really miss paper. The planet may be solved by not quite so much paper in my life, but that is certainly true.
Constance, I'm with you on that, actually. I like the paper, the attendance at court. And it's one of the points that Ayesha mentioned about getting people present. I did a case that persuaded me that it wasn't as bad as I thought, in that my client was down in Cornwall, I was in Nottingham, the hearing was in Brighton, and the solicitors for my opponents were in East London.
Wow.
And it was effectively a submissions case on an application by grandparents and application for permission to file and the rest of it. And it was a deputy district judge sitting in, I think he was in Brighton, but it was a hearing based in Hastings or somewhere. But we did it. We had 2 hours on Zoom. And it worked. It was great. It really. But you think about the logistics of bringing everybody together.
Yes.
In those settings, you just wouldn't have done it face to face.
You could never do it, and nor could you have 2 cases in a day where you had to.
No, that's right.
London. It's. I'm told that if you can master the arts of all of this, that you could actually earn more. But there is a cost that isn't just money. And I'm going to miss that. But I just wonder if we can honestly say, if there's not any further questioning, I'm just looking again at the chat. It was such a good question about divorce law, and I'm sorry that I hadn't looked that up beforehand. Is this from Miss Munira, who started us off by wishing us all a happy International Women's Day. Sirajam, I will try to get a link for you and see if I can get AstenJ to pass that on. I'm sure you'll find it, but at least I'll feel I've done something to help, and also something to thank you for starting the day off in such a nice way. Are there any other questions? Any questions that any of the panel would like to raise? Well, I think probably we can call it to an end, unless AstenJ is very keen for us to
One new
go
message.
on. Ah, here we go. No, that is,
Thank you.
sorry,
Our sponsor.
I'm just on a Zoom.
Oh, no, that's not a message. That's simply
No,
thanking us.
that was a phone call. That was an ordinary God-fearing phone call. Yeah, just coming back to the three of us, four of us here on the panel. Are there any parting words of wisdom or that might be of use to those who've come along today, so they feel they've had absolutely every drop of value out of the day?
Well, all
Well,
I can say is there's still a lot of work available in all the areas that we spoke about.
Yes.
And whether you're doing it digitally or whether you're doing it in person, the family law with the new laws that we keep getting, as they say, every new law statute that comes into being, you get 10 years worth of practice out of it. So long live the new laws.
Well, that's a good tip, isn't it? I think, yeah, it's, I wondered if it was worth mentioning something. It's not worth a whole lecture, but I think the increased emphasis on well-being is something that is interesting and that we do need to be mindful of, given the kinds of cases that we deal with, which are usually, if not always, high stress cases in some way or another. Your clients are stressed. They're in probably one of the worst times of their life. And you've got to somehow steer them through it. And I think looking after ourselves is important and really worth feeling it's all right to do that. I think that's been one improvement at the family bar. I don't know whether that's your experience. I still find that, I think partly I actually like not so much the stress, but I love the buzz of family law. I love the variety of skills that are required, and I like the law, and there's more law than sometimes family practitioners.
And it always surprises you. I used to play a game reading a set of papers for a conference, or when I became a judge, preparing for a hearing, trying to work out what they're going to look like when they come through the door. And you can always get, I mean, maybe other people are more perceptive. They're never quite what you think they are. There's another reason for doing things live, of course.
Yes.
But the case is never what you think it's going to be. The people you think you're going to have no sympathy for, you let them listen to the other side. You see another perspective and you think, no, I got that wrong.
I do think,
surprise you.
Yes, I do think the old, we're not allowed to use Latin anymore, but audi alteram partem is an incredibly important thing that you learn as you go along in this job, that there is a different point of view, that things do feel and seem differently if you're on the other side of an argument. And if you can have some insight into that, it can actually mean that you give a much better service to your client, because often they can't see it either. And it's why I quite like the question, what do you think your wife or your husband will say about this? What is she going to tell the court about why this is going wrong? Is actually quite an interesting exercise, because I've certainly been met many times with, well, I have no idea. I really, that has been the answer. So, you've got to go back to basics. But I just want to wish everyone well. We actually had a little bit of sunshine today, so let's hope that that's more of that is to come. And I think I've just had a little message saying we can conclude the webinar now. I understand that this is a new facility, which is the lectures are going to be available online for a period of time. And I hope that will be useful for some of you. And just have, have a good week. And let's hope that we will all find new ways of practicing our craft. So lots of luck and thank you so much, Stuart, Ayesha, Micheal. What a pleasure to hear what you've had to say. It's the best part of being the
Constance, keep well.
panel. Pardon?
Keep well. Thank you for
Thank
your
you very much.
Yes,
supportive
thank you,
chairmanship.
Constance.
Thank you, Constance.
Bye-bye. Take care.
Thank you.
Yes.
Everybody
Bye.
stay safe and well.
Bye. You can push.